Good morning and welcome to another edition of the Senate Committee on Commerce and Labor. Madam Secretary, please call the roll.
Senator Buck, Senator Daly, Senator Hammond, Senator Lang, Senator Pazina, Senator Scheibel, Senator Stone, Chair Spearman.
Here, and please mark Senators Daly and Hammond present once they arrive. Good morning and welcome to everyone here in Carson City and those of you who are joining us from Las Vegas. Welcome to the Senate Commerce and Labor Committee. Just a couple of housekeeping items. I'll say it a couple of times. If you get one of these, make sure it's on silent or vibrate or something so that it doesn't start singing the Star Spangled Banner in the middle of your testimony. The other thing I'd like to say is for those of you who do not know, there are 4 different ways you can participate with us in person down in Carson City. You can submit comment or you can do it on our opinion line over on the legislative website. Reminder to everyone who testifies, it is unlawful pursuant to NRS 218E.085 to knowingly misrepresent facts when testifying before a legislative committee, and anyone who does so is guilty of a misdemeanor. Myself or any member of the committee might ask you for documentation. So all committee information is available on Nellis, and we'll take public comment at the end, and public comment is 2 minutes, and it's not in reference to bills that we have already discussed. And finally, again, please turn this off or turn it on silent. And so with that, we are ready to begin. We'll open up hearing Assembly Bill 415, the first reprint, Assemblywoman Taylor. Welcome and begin when you're ready.
Good morning, Madam Chair, to the committee, Madam Vice Chair. Thank you for allowing us to come and present our bill bright and early on this Friday morning. We very much appreciate it. My name is Assemblywoman Angie Taylor, and I proudly represent Assembly District 27 in the beautiful yet rainy city of Reno, Nevada. And I am here today honored to present against Assembly Bill 415. And this bill provides provisions relating to dispensing opticians. And once again, thank you for the opportunity. A little background information. The Board of Dispensing Opticians regulates the practice of ophthalmic dispensing, and the governor is required to appoint members to that board. Last session, the legislature considered but did not pass Assembly Bill 391, which would have really cleaned up some outdated provisions relating to the board. Apparently, a last-minute amendment was proposed, and they ran up against Sine Die, and I haven't been in this building more than 15 minutes, but I know enough. If you run up against Sine Die, that means your bill is not going to make it. And so that equaled that recipe, that gave the rest of that story. So this session, we're introducing AB 415 to revise and clarify provisions relating to the licensing requirements for current licensees, and unlawful acts, and related enforcement provisions. These changes are necessary to ensure that the board achieves its primary function of protecting the public's health, the public safety, and the public's welfare. A little bit of just a bill summary. Corinne Cedrin, the Executive Director of the Board of Dispensing Opticians, is here with me, as well as Trey Abney. And Abney is the representative. He is from Abney Talking Group. He represents the Board of Dispensing Opticians. They're joining me here today in Carson City, so thank you and good morning. And then also in Las Vegas, I believe, yes, there she is. Good morning. Jennifer Ledden, who's the chair of the board of the Dispensing Opticians, is also joining us in Las Vegas in the event that there are any questions that the committee may have for her. I'll provide a brief high-level summary of the bill, then followed by remarks from Mr. Abney and Ms. Cedrin, if you'd like to walk through it, who will provide more details on the provisions in AB 415, and they're also available for questions. A high-level review of the bill is the Board of Opticians has been working on the language that would become AB 415 at its meetings over the past 2 years. It's been an ongoing effort to ensure it effectively streamlines the NRS. It's Chapter 63 37 and brings it up to date with the current realities of the profession. And this bill basically does three things. There's three main purposes. First of all, again, it streamlines and organizes the provisions, removing outdated and extraneous language. Secondly, it clarifies and simplifies the procedure for obtaining a license, including removing barriers for both in-state and out-of-state applicants. And then thirdly, it facilitates the board's enforcement of its laws so that it may be done in the most efficient and cost-effective manner possible for all parties. And we believe that this bill reflects the board's efforts on all those points, as well as the state's general interest in facilitating licensure and job opportunities. Madam Chair, that's a high-level walkthrough, and if you would like more details for the committee, we're certainly willing to do that, but I know you have 5 bills today, so I'll leave that to what is your pleasure.
Committee, any questions? Senator Daley.
Thank you, Madam Chair, and I had a couple, but I'll try to figure out which ones are most important. I was just looking over it again. So in section 18, let me get to it.
As he does, Madam Chair, may I ask Mr. Abney to have some comments as well, and
Sure.
as he gets together, and we can answer our questions if that's okay.
And maybe who's going to walk through the bill?
Would you like to walk through the bill first?
Yeah, let's walk through the bill. Maybe your questions will be answered. Okay, let's do that first.
Thank you,
okay?
Madam Chair.
Thank you. And when you're responding to any of the senators, please go direct. Okay.
Okay, thank you.
All right, thank you. Oh, excuse me. This is Corinne Sedgren. I'm the director for the board. So I'll just do a pretty brief walkthrough. Section 1 is just the heading of the amendments, and then Section 2, we've added a statement of purpose for the entire bill. Section 3 clarifies some definitions. Actually, that's sections 3 through 6 clarifies some definitions. Sections 4 and 5, again, just definitions. Section 6 is an immunity clause, which is comparable to what other boards have in their statutes regarding immunity for board members and staff. Section 7 and 8 clean up the licensing requirements in terms of licensure for apprentices. I'm sorry, Section 8 actually is a regulatory section, and it gives the board authority to regulate the terms of licensure a little more specifically in the regulations in terms of when licenses expire, the terms of licensure, and license reinstatement. I'll move on to Section 9 here. This is a fees schedule. This is, again, comparable to what other boards have in their statutes, just one single fee section where everything is laid out together, consolidated in one section. Section 10 is consolidation and clarification of complaints provisions. And then Section 11 grants the board citation authority, which is very important for enforcement actions, especially things that are just not egregious, but just something that may be a violation of one of our laws or provisions. That gives the board the ability to go ahead and issue a citation in lieu of a full-blown hearing. Section 12, again, is more citation provisions. And then sections 13 and 14 clarify the definition of dispensing optician and ophthalmic dispensing generally. Move on to section 16. Which is just exemptions to the statute for physicians and optometrists. Section 17 clarifies requirements for board members. Sections 18 and 19 update and consolidate provisions related to the administration of the board and board offices and personnel generally. Section 21, did I miss a section? I missed section 20 here. Again, this is just board offices and employment of board staff. Section 21, it has to do with gifts, grants, and donations to the board. This was previously a provision that was in our disciplinary action section. It gave the board ability to accept grants, gifts, and donations to carry out investigations. We thought that was a conflict of interest, so we just put it generally as the board being able to accept grants and donations, and that is comparable to other board statutes. Section 22 clarifies the board's regulatory authority with setting minimum standards of practice and for the lenses that will be dispensed, the ophthalmic lenses that will be dispensed. see, Section 23 clarifies which records of the boards will remain confidential. Those related to disciplinary actions have been reorganized into Sections 26 and Sections 29 of this bill. So they have not been removed, just moved to a different section. Section 24 clarifies that an optical establishment may remain open if a dispensing optician is not on site if a sign is posted telling the public that the optician is not available. Section 25 clarifies a lot of our licensing requirements. It also allows for license reciprocity and expedited licensing for military personnel and their spouses, and transfers from states where they do not issue licenses for dispensing opticians. That takes care of a lot of these provisions here. Section 26 updates the types of records the board will keep for its licensees, public records. Section 27 consolidates all the provisions related to limited licenses together into one section. The board no longer issues limited licenses. It has not done so since 2004, so we just want to consolidate everything related to those licenses to a single section. So at some point, if the statute is amended in the future, we can just remove those provisions altogether if we no longer have limited licenses. Section 28 clarifies the requirements for employment of licensed dispensing opticians and also the oversight of apprentices. Section 29, again, has to do with complaints, disciplinary actions, specifically unprofessional conduct of a licensed optician. Sections 29 and 30 together streamline provisions related to complaints, the board's subpoena power and investigatory powers and hearing powers. And then Section 30 as well has to do with actions against unlicensed individuals. Section 31 has to do with subpoena power and issuing citations. I'm sorry, not subpoena power, issuing citations pursuant to the earlier section, Section 11 of this bill. And then Section 32 is adding two unlawful acts, which is holding oneself out to the public to be an optician without being licensed, and then violating a prescription, a date given on the prescription. So Section 32.5 is just an amendatory provision having to do with limited licenses again, just putting a fee cap on the amount for reinstating a limited license. So, no, that's a very brief overview. Are there any questions, or would you like any more detail on any of the specific provisions?
Thank you. I'll go to Senator Daley and then Senator Pazina.
Thank you, Madam Chair, and that helped me go back and look at some of my questions so I can have my thoughts straight. And so just wanted to be clear, and I'll go to Section 5 first. The way I'm understanding that is that at every actual location where you have it, where you're actually doing the dispensing and doing the work, there has to be a licensed professional there. But if there's a chain and there's 20 of these offices, the management office where they're not doing any dispensing, they don't have to be a licensed person. Is that the way I was reading that?
Yes, this is Corinne Sedgren for the record. So that's correct. So optical establishment clarifies that we're speaking just about the department where the dispensing takes place.
And I just wanted to make sure that's the way I was understanding that. So where the actual practice is taking place at each individual location, we'll have a licensed professional there.
Correct, yes.
Okay. And then I was just, in 18, you're changing when you're going to have the hearings. So how are the hearings going to be carried out? You switch into a fiscal year? Are there set schedules, or is it just once a year? If I'm reading 18 correctly.
I'm sorry, could you clarify, are you speaking with respect to disciplinary hearings, or which types of hearings?
Yeah, whatever's in Section 18. Sorry,
Oh,
I'm going back
Section
to
18.
And so you'll meet at least once each year, majority of the members, et cetera, and you're switching to a fiscal year.
So Corinne Sedgren, to clarify, no, we've already been operating on a fiscal year. We've just reorganized and streamlined some of the provisions, so this is in a different section now, but we previously already had this in our statute that we would operate on the basis of this fiscal year.
Okay. And then in Section 23, And I know, I heard what you said in your explanation. You said that you're clarifying. Unfortunately, I would disagree that it's clarified. So you're making additional records and various things, if I'm reading this correctly, especially when you get down to the bottom of it in section 5, line 14. It says, any other information or record in the possession of the board that is not a public record subject to provisions of NRS 239. And I know committee has heard me talk about the public records and the way all that stuff works. So unless it's declared to be confidential, it is a public record. So that language to me is backwards. So
All right, so the intent here, this is Corinne Sedgren again, is to clarify that we are going to be in compliance with all of Nevada's public records laws, but if it's not a public record according to Nevada public record laws, then we can keep it confidential. And we actually had, this is section 23, if you look at the cross through subsection D, it had previously said any other information or records in the possession of the board. So this was to clarify any information or records in the possession of the board that are not public records subject to those provisions. We just add that clarifying clause at the end there. But it had already said any other information or records in the possession of the board would be confidential.
understood. And just because it said that before doesn't mean it was right, and that's why I'm bringing it up now. And I know you're removing some provisions at the top about decisions of the boards, et cetera. So when does that stuff become public? Because that's my next question. So the final complaint in action, that should be public record. But this would indicate that it wouldn't be and that you can keep it confidential. And I want to make sure that that can't happen.
Right, and so we actually did reorganize that. That's now in section 29. So if you look at section 29, I'm on page 17. At the very top, subsection 7 says, "In order of the board that imposes discipline and the findings of fact and conclusions of law supporting the order are public records." And that's the exact same language that was in the other section where it was struck through. We just reorganized it into the section pertaining to disciplinary actions. So anything that's a disciplinary action, findings of fact of the board will still be subject, and I believe it is under public records laws anyway, under Nevada public records laws, it would be subject to a public records request. But we have not removed that provision, we've just moved it.
Thank you. And I'll take a look at it, and if you can come talk to me, and we'll make sure we're clear on that.
All right.
Final thing I got is when you talk about in section 26 sub 2, and I hope that's not a reorganization thing, and you talk about the copy fee at the end.
Right. And again, this is Name. Oh, I'm sorry, Corinne Sedgren. Thank you. No, thank you. It's like, what is that? Yes, Corinne Sedgren, director. So the request fee is again congruent with Nevada public records laws, which says that we can charge a fee for the time for the staff. So we just wanted to clarify in our statute as well. So this just says fees for copy, and it is just the fee that is incurred by the board. So we don't think we're being excessive. But as far as this section, we, again, here, subsection F says the name of each holder of a license who has been subject to disciplinary action by the board is going to be a public record.
And I'm fully aware about the fee and NRS 239 and various things, and that's where we've set it, which applies to everybody.
Right.
So when I look at these things and you guys put it over there, I think it just creates confusion in our statutory. To me, why not just refer that you'll charge a copying fee in accordance with NRS 239, which is already said, which already applies to everybody. Having that language where you're going to say, hey, it's just our actual costs infers and actually puts in a potentially different standard than what's in 239, which you wouldn't be able to conflict with. So it would be easier, and I think it would be more consistent with what we've already done, was to say reference 239 rather than reasonable cost, because in 239 you can only charge a reasonable cost already.
Yes, understood. And this is Corinne Sedgren again. We did rely upon other board statutes when drafting a lot of these provisions. So I believe that that was something that's pretty common in other board statutes, but that is
And-
certainly something we
and-
can address.
And if I get a chance, I'll correct it in those ones as well.
All right. Understood. Thank you.
Senator Pazina?
Thank you, Chair, and thank you so much for the presentation. My question will be a lot quicker, and I only have one. In Section 24, sub 2 on page 13, I was curious. I noticed that there should be signage available if the license dispensing optician is not present. In the past, were offices closed when the licensing optician wasn't present?
This is Corinne Sedgren for the Board of Opticians. In the past, it wasn't clear, and we had a lot of questions to the board regarding whether they could stay open or not. And we went back and forth on the management, if the manager had to be there to open the store. So we just wanted to clarify it in our statute that, yes, you can remain open. The ophthalmic manager does not need to be on site, but a sign needs to be posted. Thank you.
Senator Stone?
Good morning, Assemblywoman, and thank you for the presentation today. My question is on Section 21, number 2, the board may accept gifts, grants, donations, and contributions of money from any source to assist in carrying out the provisions of this chapter. Are the gifts, are you referring to monetary gifts, or are you talking about material gifts as well? And if so, what kind of gifts are we talking about, and where are they going to be used? Are they going to be showering board members with people they're going to be regulating, or what?
Thank you. This is Corinne Sedgren again. So we have never received a gift that I'm aware of, grant or donation. This was a provision that's been in our statute, I believe, for many years, but it was pertaining to the ability of the board to do investigations, and we didn't think that sounded right to have a gift given to conduct an investigation. So as far as I understand this provision, the individual board members may not receive gifts. It would just be the board as a whole, and it would be for operating costs. As far as donations and other contributions that are not a monetary gift, I don't even know what that would look like, honestly. It would just be a monetary gift for the administration of the board.
So is this provision even needed? It hasn't even been utilized.
I suppose it has not been utilized, so I suppose we could remove also the contributions or things that are not monetary contributions. I don't understand that we
I think it just raises flags of
All right.
bias,
Yeah.
if you will.
And
So-
again, not that it matters, but it was congruent with other board statutes.
I mean, if
They
somebody
also
wants to
have these
make
provisions.
a benevolent person wants to give
Right.
$1 million because they believe in opticians and wants to further their education and give it to the board, I don't have a problem with that. But
Right.
but when you put gifts, it raises flags when you have a regulatory board. So
Right.
I appreciate that. Thank you so much.
Thank you.
Senator Hammond?
Thank you. I don't really have a question. I just want to apologize for my tardiness and thank the Assemblywoman, but I'm already a yes when I walked in, so I was okay.
Thank you, Senator. You can be late anytime you want to.
Dr. Taylor, you have someone down south. Are they part of your presentation?
Angie Taylor, for the record. No, she was there. She is the chair of the board of dispensing opticians, and so Jennifer is there if there are any questions that the board should, that should be answered by the board.
Okay. Seeing no further questions, if you want to step back, and we will open it up now for public comment. Those in support of Assembly Bill 415. Anyone here in Carson City in support? Anyone in Las Vegas in support? BPS, anyone on the phones?
If you would like to testify in support of AB 415, please press star 9 now to take your place in the queue. Good morning. This is James Morris, and I am the General Counsel and Executive Director for the American Board of Opticianry National Contact Lens Examiners. My apologies for not being able to be present in either location. I just rise in support of this and would answer any questions if you have any. Thank you.
Can you spell your name, please?
looks like we lost them.
Okay. Anyone else? BPS?
One moment, Chair.
And just ask the people once they open up to spell their name, because sometimes it doesn't come through on this end.
Yes, Madam Chair, this is James Morris. First name James, Morris, Morris.
BPS, anyone else?
The public line is open and working. There are no callers at this time.
Okay, thank you. We'll move now to testimony in opposition of Assembly Bill 415. Anyone here in Carson City? I don't see anyone moving to the table in Las Vegas. BPS, anyone on the phones?
If you would like to testify in opposition to AB 415, please press star 9 now to take your place in the queue. Caller 153, go ahead.
Good morning. My name is Joe Neville. The spelling is Joe for my first name, and my last name, Neville, is spelled Nev, like Victor, Ille. Thank you for the opportunity to weigh in on this piece of legislation. I'm going to say we're opposed to the bill as drafted, primarily because we have a number of objections and suggested changes that we think are important to be made to the bill. Nevada is one of 20 states that license opticians, and it is the most restrictive state in the union. We sent in a letter dated April 28th about some of our concerns, but it relates to the fact that in reality, there is no reciprocity between the licensed states. Unlicensed people are unwelcome by the board to work in our stores. Our association, the National Association of Retail Optical Companies, is made up of large and small optical firms throughout the United States. And Nevada is one of the most difficult states for our folks to work and operate in. So we've made a number of suggestions, not to deregulate, not at all, but to bring Nevada more into the mainstream. And so we appreciate any opportunity that you have to take a look at our letter and consider our suggestions in order to make life a little bit easier on optical companies in the state. Thank you very much.
The public line is open and working. There are no callers at this time.
Thank you. We'll move now to those testifying neutral, either here in Carson City and in Las Vegas. See no one moving. BPS, anyone on the phones?
If you would like to testify in neutral for AB 415, please press star 9 now to take your place in the queue. The public line is open and working. There are no callers at this time.
Thank you. Senator Taylor, closing comments?
Thank you, Madam Chair, and thank you, Senators. Again, I just want to thank you for hearing our bill this morning, starting your Friday morning with this, and we urge your support for Assembly Bill 415. Thank you so much. And looking forward to working with Senator Daley, as well as we'll talk about some other things. You bet. Thank you so much.
And so, Assemblywoman, in light of what the previous caller said, we've had several bills. This session has been ophthalmic. Is that eye-opening?
That's good.
It's early, yeah. But I know we've had a number of bills that deal with this particular profession, so you may just want to check and see. All of our bills are over in your house, but just check and see if his concerns have been answered. And if not, I always encourage people to get with the sponsor. And whatever the sponsor says, that's what we do.
No, I appreciate that. Angie Taylor, for the record. He referred to a letter that I am not in receipt of. And it doesn't seem as though it isn't in our exhibits. And so I'm hoping that I actually get the letter and we can begin with that. And I'm certainly happy to have conversations and see where it makes sense, if it makes sense, to do anything, if it solves a problem that needs to be solved. But if it bogs the bill down and doesn't solve a problem, I just have to talk to him next time.
Okay.
Okay.
Thank you.
Thank you so much.
Thank you. And with that, we will close the hearing on Assembly Bill 415 and open the hearing on Assembly Bill 401. Assemblywoman Howdy. The measure provides its provisions governing schools of nursing.
Thank you. Good morning, Chair and members of the Commerce and Labor Committee. I'm Assemblywoman Sandra Howdy, and I proudly represent Assembly District 41. As our frontline healthcare workers, nurses take an all-encompassing view of a patient's well-being so that they can provide care and treatment the moment a patient needs it. To simply put it, nurses are essential in providing care and producing positive healthcare outcomes. A groundbreaking Penn nursing study from 2002 found that a lack of nurses directly relates to increased patient mortality. Unfortunately, we are facing a historic shortage of nurses. Nevada needs to recruit more than 4,000 registered nurses just to meet the national average. We have seen this problem play out all too frequently recently. We are all familiar with COVID-19. When cases surged and capacity collapsed, doctors and nurses had to triage their care in order to save as many patients as possible. Just this winter, a combination of RSV, the flu, and COVID-19 infections created a dire situation that caused our pediatric ICUs to reach capacity and nearly saw us see the same horror as the depths of 2020. The problem is here, it's getting worse, and we need to act now. That is why this session I brought Assembly Bill 108, Assembly Bill 401, and Assembly Bill 443. All three of these measures help in creating the nurse pipeline that is essential to fundamentally addressing this shortage in the long run. One solution is not going to solve our nursing shortage. This is an all-of-the-above approach that we need to do to tackle this problem and ensure that we stabilize and support Nevada's healthcare system. Unfortunately, Assembly Bill 108 did not make it across the finish line, but Assembly Bill 401 and Assembly Bill 443 have made it over to your House, and I look forward to the positive impact that they will have in our state. Assembly Bill 401, which is the bill you have before you today, was a product of the Interim Commerce and Labor Committee and came at the recommendation of SEIU. Assembly Bill 401 will help increase nurses in Nevada by creating permissive language that allows a school to increase the student-teacher ratio from 8 students per 1 teacher to 12 students per 1 teacher. It's important to know that this language is permissive only. It does not mandate that schools automatically go to 12. It simply lifts the statutory requirement that caps them at 8. For instance, one school may want to increase the number of students from 8 to 12 and see how it works for its program. Another school may not want to increase the current ratio and will stay at status quo. Chair, with your permission, I would now like to turn it over to Mr. Patrick Kelly with the Nevada Hospital Association for remarks, and then we will be open to questions.
Madam Chair, members of the committee, my name is Patrick Kelly. I'm the CEO of the Nevada Hospital Association. Today, it's my privilege to present AB 401. I'd like to thank the sponsor of the bill for recognizing the needs of citizens and healthcare providers in Nevada, and for all her efforts in improving the nurse pipeline. AB 401 is one step toward increasing the number of nurses in Nevada. This bill is very simple. It allows a school of practical nursing or a school of professional nursing to increase the size of its classes. Currently, nursing programs are limited to a faculty to student ratio of 1 to 8, 1 faculty member to 8 nursing students. AB 401 permits nursing schools to increase their faculty-to-student ratio to 1 faculty member to 12 nursing students. As was pointed out, increasing the size of the class is not mandatory. Each school will get to decide. Our nursing pipeline could expand by 50% if nursing schools adopted the 1 to 12 ratio. Please keep in mind that this bill addresses only one piece of the pipeline challenge. Nursing faculty wages need to increase. They're not competitive with the private sector. Clinical training also needs to be evaluated. We need staggered clinical training hours, and we need to explore ways in which healthcare providers can assist in training. Fortunately, several bills are before the legislature that provide additional funding for nursing schools. SB 375 is one, and support for nursing students, AB 443. We believe additional resources are on their way to help nursing programs. We want this piece of the puzzle to be in place when those resources arrive. AB 401 can also help students in Nevada. Each year, hundreds of qualified students are denied entry into our nursing programs because our programs are at capacity. Students who want to be nurses become discouraged and move on to other careers. The big question is this: why are we turning away qualified students who want to be nurses when we have a severe nursing shortage? Our state's goal should be to enable every qualified student to become a nurse. The Legislative Council Bureau prepared a report on the faculty requirements in other states. This report is included in your packets. The LCB found that for schools of practical nursing, 19 states have an established faculty-to-student ratio higher than our current ratio of 1 to 8. 9 states in the District of Columbia have no specified ratios or do not regulate ratios. For registered nurse programs, the statistics are similar. 16 states have ratios higher than our current ratio of 1 to 8, and 11 states in the District of Columbia have no specified ratios or do not regulate ratios. It's not unusual to have a faculty-to-student ratio above 1 to 8. Nevada's nursing statistics are poor. As pointed out, we need more than 5,000 RNs and LPNs just to meet the national average. 41% of our Nevada RN licenses are held by nurses with out-of-state addresses. During the pandemic and after, healthcare providers brought thousands of traveling nurses into the state, and their licenses remain in effect for 2 years. We believe the large number of traveling nurses distorts the number of licensed nurses in Nevada, and thereby keeps the number of nurses we need artificially low. Last summer, the NHA conducted a survey of our member hospitals. We asked, how many open RN positions do you have on July 1st, 2022? The answer was over 2,300 open RN positions. We asked the same question about January 1st, 2023. The answer was over 2,400 RN positions. Please keep in mind that survey only applied to hospitals. Nursing homes, home health agencies, schools, public health, and numerous other healthcare providers were not included in the survey, and we know they need nurses too. Vivian Health, a national healthcare hiring marketplace, issued a report estimating the demand for nurses from 2020 through 2030. It ranked Nevada as having the 3rd largest increase in demands for RNs in the United States. The change in demand for RNs is expected to be a 23% increase. That's substantial. Nevada clearly needs more nurses. AB 401 is one piece of the puzzle in increasing our nursing pipeline. Thank you.
Thank you, Madam Chair. And again, we brought copies. This was an LCB Research Division report that they created for Senator Ganser, which was helpful with her Senate bill as well. And so I felt that, I'm sure you've seen this document already during her presentation, but I thought it was helpful to hand out again so that you guys can again see in front of you the student to faculty ratio that other states have in comparison to Nevada. And again, Assembly Bill 401 is just one component of increasing the homegrown nurses that we have here in Nevada. Also, a recommendation from the interim Commerce and Labor Committee, which Chair, you sat on with me, and a couple of members here sat on with me, was also, expanding the Millennium Scholarship to other nursing institutions, which will also be before this House. Currently, right now, 7 schools accept the Millennium Scholarship for nursing programs, and we're hoping to expand that to 9 schools currently take Millennium Scholarship for the nursing program, and the other bill I have, Assembly Bill 443, will help expand it to an additional 7 schools. Again, just doing what we can to help increase that nursing pipeline in our state.
Thank you. Have anyone else to present? Assemblywoman? No? Okay. Questions, committee? Senator Hammond?
Thank you, Madam Chair. Good morning, Mr. Kelly and Assemblywoman Hannigy. So the bill itself addresses, and I think in your comments, I thought it was pretty succinct. You said there's a problem when we're dealing with a workforce shortage in a lot of areas. Matter of fact, that's what I do most of the time, talk about how to increase our workforce, how to educate our workforce. And you mentioned a couple of, this bill right here is going to address one issue of, I think, 3, increasing the ratios, which I have no problem with. Matter of fact, I think if you have a really good instructor, there shouldn't be any ratios. It should be dependent upon the particular instructor, as a matter of fact. I think that some are better than others. And so if you have a really good instructor in a class, then they can handle a larger load, and I have no problem with that. The question I have for you in particular is when you made that comment about paying instructors. I think that's a prevalent problem almost across the board when you talk about anybody who's trying to develop a workforce, and that is getting qualified people to come in and be instructors. Have you found any, and this is probably not necessarily pertaining to the bill, but I'm very curious to find out, have you come up with some sort of solution, a workaround when it comes to finding qualified people to come into the classroom?
Thank you for the question, Senator. Assemblywoman Sandra Howdigi, for the record. And we haven't specifically come up with any solutions, but I know that one of your colleagues, Senator Ganser, has a bill that would help address funding for nursing program. And I believe, I don't know if this is the exact bill number, but I think it is. It's Senate Bill 375, which would help provide extra funding for nursing programs in our state.
Please, thank you.
Madam Chair, may I address the senator directly? Thank you.
Yes,
Pat
please do.
Kelly, for the record. One of the things that I've found out recently is that in higher education, there are certain departments that are allowed to pay faculty members more. And the example that was given to me was the engineering department. They pay their engineering professors a little bit more than other professors. So I'd like to explore how we can get that exception in for nursing programs.
That I'd never heard, so that's a great suggestion. I do want to talk to you offline because I think there's other things outside the box thinking, bringing in nurses from the industry, bringing them in and having them instruct for a short period of time. But then that also requires some sort of work around another bill or maybe language we could put into a bill or something.
Pat Kelly, for the record. Senator, there are actually hospitals that provide a master's degree RN to a school, especially in the rural areas, to teach. So they work at the hospital, but they're kind of like an adjunct professor at the school. So, I mean, those models are starting to develop.
That's what I'm talking about right there, thinking outside the box and trying to find the ways to educate the potential workforce out there. But we need that because it's hard for somebody who makes a lot of money to leave that and then go into a profession that doesn't pay a lot of money. So there's got to be workarounds. I think this is a great first step, in tackling what you have as a shortage in your workforce. So I'm very much in favor of this. So thank you.
Senator Stone, then Senator Pezzina.
Thank you, Madam Chair, and thank you, Senator Howdigi and my friend for the presentation. And I appreciate the permissive ratios and letting the schools know better how to educate our nurses with the desire to have more or less instructors. And I would say that with the present day technology as it's advancing, I think it will allow the schools to appropriately have higher ratios. And obviously these schools have to provide a good education because these nurses need to pass their board exams before they could be registered nurses, and a school certainly doesn't want a reputation for having a large failure rate. So they're not going to compromise the quality of the education with respect to the outcome of the exam. So this is going to provide for the long-term increase in the number of nurses, and I appreciate that. Unfortunately, we saw the nursing compact bill in the Assembly that failed, which was rather unfortunate, and I'm hoping that soon the state will recognize occupational licensing as a tool, kind of reciprocity with other states, to bring some of these instructors into the state to help with the expansion of our needs here in Nevada. But Senator Summerlin, thank you for bringing this forward. I think this is going to help us address this shortage. Appreciate you.
Thank you, Chair, and thank you so much, Majority Leader Howdigi and Mr. Kelly, for the presentation. And this is a comment, not a question. The Assemblywoman and I spoke toward the beginning of session, and we were probably having very similar conversations with our constituents who are nurses in regards to the incredible need that we're facing right now. So I love the legislation, and thank you so much.
Additional questions? Comments? Okay. Someone, any other presenters? No? Okay, if you'll just step back, and we'll open public hearing now on those in support of Assembly Bill 401.
Morning, Madam Chair and committee. My name is George Ross, ROSS. I'm representing HCA, which is the company that owns Sunrise Hospital, Mountain View Hospital, Southern Hills Hospital. We'd like to thank Leader Howdigi for bringing this very important bill. We are strongly in support. Anything I would say would largely echo what Mr. Kelly said, and we hope you were listening to what he said, because we think he's right on the button. And I will say that we are not ready to talk about the details yet, but we are working on something to help solve this problem as well. Thank you.
Thank you.
Good morning, Chris Bossy for the record. I'm here today on behalf of Renown Health, and I'd just say ditto. We think it's great legislation. Thank you very much.
Thank you. Anyone else here in Carson City? Anyone in Las Vegas? BPS, anyone on the phones?
If you would like to testify in support of AB 401, please press star 9 now to take your place in the queue.
Good morning, members of the committee. My name is Marlene Lockhart, representing SEIU 1107. We are in strong support of this measure and feel it is one of several measures moving through the legislative process that can help alleviate the nurse shortage in this state. Research has shown that there is a positive correlation between the number of nursing faculty members and the number of nursing graduates. For example, a study conducted by the American Association of Colleges of Nursing found that schools with higher nursing faculty to student ratios had higher graduation rates than those with lower ratios. Increasing the number of nursing faculty members would also help to address the issue of faculty shortage, which is a contributing factor to the nursing shortage. Many experienced nurses leave the workforce to pursue teaching positions, but there are not enough faculty positions available to meet the demand. By increasing the number of nursing graduates, more nurses would be available to meet the growing demand for healthcare services. And again, we strongly support this measure. Thank you.
Thank you. BPS, anyone else?
The public line is open and working. There are no callers at this time.
Okay, we'll move now. Public testimony in opposition. Assembly Bill 401. Don't see anyone here. No one's moving in Las Vegas. BPS, anyone on the phones?
If you would like to testify in opposition to AB 401, please press star 9 now to take your place in the queue. The public line is open and working. There are no callers at this time.
Thank you. Move now to public comment, public testimony, neutral. Assembly Bill 401. Don't see anyone moving. BPS, anyone on the phones?
If you would like to testify in neutral for AB 401, please press star 9 now to take your place in the queue. The public line is open and working. There are no callers at this time.
Assemblywoman, no closing comments. I just have one because when Mr. Ross came forward in support, I think we've come full circle. In 2013, both sides were gathered in my office in support or opposition for a nurse-patient ratio, and I think you made the comment that we probably needed a little bit more, some more instructors. So on the heels of that passing, now we've got it. Well, at least we have the bill, okay? All right, thank you. And so with that, we will close the hearing on Assembly Bill 401. And open the hearing on Assembly Bill 318. Assemblyman Nguyen revises provisions governing certain providers of health care. Welcome, and please begin when you're ready.
Good morning, Madam Chair, and the most efficient members of the Senate Commerce and Labor. Thank you for the opportunity. My name is Yui Nguyen, and I have the honor to represent Assembly District 8 in the beautiful Southwest Las Vegas. I am here to present Assembly Bill 318, and just to keep up with the efficiency, I will make it very short. I brought 2 phono friends, so that will help alleviate some of the disconnect from any questions that I may not be able to answer. Assembly Bill 318 is a cleanup bill that makes administrative changes to the State Board of Medical Examiner and is consistent with what many agencies bring forward concerning the oversight of healthcare. Co-presenting with me over Zoom is Sarah Bradley, Deputy Executive Director of the Nevada State Board of Medical Examiner. She is way better than I am in terms of going through the bill administrative statutes and the fees and fine that the Board of Medical Examiners collect. Additionally, a representative from Nevada State Treasurer's Office is available to answer any questions on how funding for fees and fines are diverted and what sort of accounts can benefit those in the healthcare field. And now I'd like to pass it over to Ms. Sarah Bradley to expand on the bill. Madam Chair.
Good morning. Thank you, Chair Spearman and members of the committee, and thank you to Assemblyman Nguyen for bringing our bill this session. This is Sarah Bradley, Deputy Executive Director of the Nevada State Board of Medical Examiners. I will go ahead and go through the sections of the bill for you. So Section 1 allows the state treasurer to use the fine money received by the board in disciplinary actions for the improvement of healthcare in the state, as well as the improvement of the practice of medicine in the state of Nevada. Section 1.5 clarifies provisions regarding expiration of licenses and updates the requirements to report the expiration of licenses by the board to other agencies, the Drug Enforcement Administration, as well as the Board of Pharmacy. And instead of sending a copy of an expiration notice, we'll now send a list to them, which we think will be more helpful. Sections 2, 4, and 5 ensure that all board license types are included in the reporting requirements for licensees with regard to malpractice payments and claims. And Section 3 makes the same change, but it also clarifies that the report that a licensee gives needs to include the dollar amount of the payment. We've had a couple questions about that come up more recently, and we want to clarify that the dollar amount does need to be included. And then Section 5.5 increases the maximum fine amount from $5,000 to $10,000, and that's just the maximum that the board could assess in a disciplinary matter. This amount has not actually been changed since 1985, and so we think it's time to give the board a little bit more room here when assessing fines. And I'm available for questions. Thank you.
Thank you, Madam Chair, and with that, we are ready for questions.
Thank you. Committee members? Senator Stone, then Senator Daley.
Good morning, Assemblyman, and thank you for the presentation. I was just curious, most of the fines that are collected by various regulatory bodies here go into the general fund. So we're creating a bit of an exception. Can you explain the importance of why you want to do that?
Thank you, Senator. I'm going to, apologies, Madam Chair, through Senator Stone.
Go direct.
Thank you very much. Again, Yui Nguyen for the record, Assembly District 8. The intent is to, going through some of the bills that we have this session, we wanted to look at, there are current bills that are funding the programs to help with the reimbursement of student loan for healthcare providers that want to work in underserved areas. So rather than it going to the general fund, this types of fees could go towards that program or any other similar program, let's just say if that bill doesn't pass, so that we can create additional resources for providers that want to practice in underserved areas. And I don't know if the Treasurer's Office want to add on to it. Not sure if she's on the phone, but that's the intent at this time.
Madam Chair, members of the committee, my name is Tom Clark. I'm here on behalf of the Board of Medical Examiners, and Ms. Bradley is also available. Just in previous testimony, the Treasurer's Office has clearly stated that they have accounts where they can move these dollars to benefit members of the healthcare community, whether it be student loans, as Mr. Nguyen brought forward, or other types of programs. So if there is going to be a fine levied against a provider by the Board of Medical Examiners, those dollars are captured to benefit the medical community. Thank you.
And if I can follow up with you, has this program, is it going to be set up in response to this if it becomes law, or is there already a mechanism in place to vet applications and get people into underserved areas to practice medicine here in Nevada?
Thank you, Madam Chair. To Senator Stone, Tom Clark again for the record. There are a number of different accounts within the Treasurer's Office that they can use. The programs themselves have been created and are by nonprofits and other different organizations that then have that whole application process. The state really is just the manager of those funds. Thank you.
Thank you, Madam Chair. My question's along the same lines on that, and maybe you can come and educate me a little bit later. But when I read this, so it's going to be a new account, and then it just can be used for the improvement of healthcare or the practice of medicine in the state, which is pretty broad. So again, on this separate account, and I understand there may be others, but that's not what we were talking about. So what are the parameters going to be? What are the application process? What is the mechanism for that money to be transferred out and spent? Is it done by the treasurer? Does it have to go to interim finance in order for those things to happen? Again, that's, like I say, it's a diversion from the state general fund, which then if it's going to be spent, has to go through the regular process for the expenditure of funds under state law. So if it gets diverted over to a separate account, does it still have to go through those same processes? What is the application going to be for this? What are the parameters? Are there going to be regulation? What's the rest of the details? Because this doesn't really give up much.
Thank you, Madam Chair. Again, for the record, Tom Clark. I don't have the specifics on that, but I would be willing to bring Mr. Jimenez or the Treasurer to your office. The Treasurer has Assembly Bill 45, I believe it is, that actually creates a specific account to benefit those programs. And he has the details as to how that particular program would work. Now, we made the language, we didn't want to make it specific to a program that hadn't been created yet, but there are plenty of other accounts in existence that provide for these types of programs.
And if I can follow up and to quote, not someone I agreed with too often, Ronald Reagan, right? Trust but verify. So if you want to do this, I need to see some more information.
For the record, Tom Clark, we will do our best working collectively with the Board of Medical Examiners, the Treasurer's Office, and the sponsor to bring that information to light. Thank you.
Additional questions? So I just have a couple. One of the things that's said here in the bill, and I believe it's section 2, Yeah, section 2. 1, the insurer or the physician, et cetera, shall report any action of malpractice against the physician assistant, respiratory care, et cetera. And then it comes down to sub 2, and it indicates if they don't do that, then there's a fine of $10,000. So my question is, sometimes, not all the time, but sometimes physicians are reluctant to either do that process, report someone with malpractice, or to testify against them. So is there any mechanism in place to ensure that when malpractice occurs, that physicians will do it based on conscience? But if not, then do you have anything that would be able to go back and verify that, yes, this was an egregious error, and it should have been reported by whomever was there, whomever observed it, and for that reason, then they'll take disciplinary action. Understand my question?
Chairman Spearman, I'm not sure that I do. This is Sarah Bradley, Deputy Executive Director, for the record. I don't believe that portion of the statute is being amended. It's the amendment in section 2 right now is just adding all of the board's license types to the requirement that if a malpractice claim is filed, that they have to report that to the board. Right now, physicians are the only ones that are required. If there was an error, meaning they didn't mean to, the board looks at all of those on a case-by-case basis, and the board does not routinely go after people for failure to report in a very strident way. Generally, our goal is to get the information so that we can look at the underlying issue. The reason for these reports is so that the board knows that a malpractice matter is pending that may involve patient care. That way we can investigate it, and we can potentially see if we have a practitioner that we need to work with to get them educated or otherwise to be more competent. So that's the reason for the report, not to try to punish them. It's really to try to get them on a good path if there is a problem. Then, of course, in really egregious cases, there could be strident action, but we look at the patient care itself, not so much the report or failure to report.
Thank you, Ann. I appreciate that because I recognize that that's what you do, but there are times when families, you can't go back and unring the bell if that malpractice causes death or some other type of permanent injury. And so that was the basis of my question. Making sure that people understand it's a duty of every medical professional to make sure that they police themselves. And if there is someone who is creating situations that are unsafe for patients, that there is some type of leverage quote that you might have to ensure that the reporting would take place.
Okay, so Chair Spearman, I think you're asking then about not a duty to report a malpractice claim like a civil action. You're asking about the duty of a licensee to let us know if another licensee is acting improperly.
Exactly.
And I would say the board is complaint driven. So we need a complaint in order to investigate and possibly take action generally, although we do investigate based on self-reports. A report like that, we do receive them. Where other physicians, generally it's physicians, are letting us know. We treat all of those as essentially a complaint, and we open investigations and look into them. We do have I believe there's some educational outreach that tells physicians that they have a duty to let us know about potential problems. But otherwise, I would say I'm not aware of a situation where there's been a case against someone for failing to report in the 3.5 years that I've been with the board. But it is something that the board would look at, and definitely if, that person could potentially get disciplined for failing to let the board know.
Thank you. And I have a constituent that would probably need to talk with you about that matter, and that was the genesis of my question. Okay?
Okay.
Thank you.
Thank you.
Assemblyman Nguyen, any further presenters?
Madam Chair, you will win for the record? Nope, that's all we have for now.
Okay, so if you'll step back, then we'll open up public testimony for those in support of Assembly Bill 318.
Madam Chair, members of the community, the committee, this is Dr. Brett Fry. I'm a member of the Board of Medical Examiners, have been for almost 4 years now. And I looked at this from an ethics and public service perspective when I came on the board as to where the flow of funds were going, and felt it was really in the best service of especially rural Nevada, those that need mental health, better mental health in their communities, that we would have the ability to use those funds rather than having them go into the general fund. So that was the nidus of this bill, essentially. And I think that these funds have a myriad of opportunity, and to Senator Daley's point, I think there's some specifics that need to be sorted through. However, I don't want that to necessarily take us away from the big picture here, which is opportunity. Thank you.
Good morning, Chair Spearman and members of the committee. My name is Nick Schneider. That's SCHNEIDER, and I'm representing the Vegas Chamber. And the Chamber is in support of AB 318. We appreciate the efforts to kind of clean up this process, as well as divert funds to support our medical providers. We also appreciate that this bill does add a 60-day notice period for the expiration of licenses to provide our medical providers with a little bit more notice to make sure they have those fees paid. Thank you so much.
Anyone else in Carson City? Anyone in Las Vegas? BPS, anyone on the phones?
If you would like to testify in support of AB 318, please press star 9 now to take your place in the queue. The public line is open and working. There are no callers at this time.
Okay, we'll move now to those in opposition. Assembly Bill 318 here in Carson City, in Las Vegas. BPS, anyone on the phones?
If you would like to testify in opposition to AB 318, please press star 9 now to take your place in the queue. The public line is open and working. There are no callers at this time.
Anyone here testifying neutral, Carson City or Las Vegas? BPS, anyone on the phones?
If you would like to testify neutral to AB 318, please press star 9 now to take your place in the queue. The public line is open and working. There are no callers at this time.
Okay, thank you. Zimmerman, closing comments? Okay. And so with that, we will close the hearing on Assembly Bill 318 and open the hearing on Assembly Bill 442. The measure revises provisions relating to persons licensed by the Board of Medical Examiners. Someone Peters is on her way down, so we'll just take a real short recess until she gets here. We're in recess. We're back in session. Welcome, Assemblywoman.
Thank you, Madam Chair and committee members. Thank you so much. I am Sarah Peters, Assembly Representative from District 24 in Reno. And I am pleased today to present to you Assembly Bill 442, which has been an extreme work of coming up with a solution for a problem that was presented by a constituent related to a scenario in which a physician abused their position of power to harm a patient. I want to start with some history on this. We all know that there's like the social license of physicians, right? We appreciate our doctors and trust our doctors and those who provide healthcare to us. And that institution is an important institution, and that safety and feeling of validation and security in a healthcare setting is imperative to our health and the service that is provided by healthcare providers. However, being a healthcare provider also comes with a perception of power, right? That you know more about a subject than anyone else in the room. And that is also important to protect. However, it can be abused, and we know this. Positions of power can often be abused. And if there aren't the correct regulations in place or oversight in place, people can end up harmed, and particularly our most vulnerable people can end up harmed. So Assembly Bill 442 is an attempt to give a backstop for some of the most egregious abuses of that power in our medical institution, that being sexual assault and domestic violence against patients. When you have been the victim of domestic assault, violence or sexual assault by a healthcare provider, it's one of the most difficult positions to be in as an accuser, right? To say this person who has this position in our society, right, who has this social license to do this work, who has this education and background, has harmed me against their ethics, right, has put me in a place where I am no longer safe. And that admission, that accusation, it puts people in a very difficult position in our society, including those who regulate our physicians and other healthcare providers. So I worked with the Board of Medical Examiners and law enforcement over the last couple of months on what can we do to help create a backstop that says in the event that a patient, a victim, has come forward to say, I have been harmed by a physician in these ways that we should take very seriously, and we do take these things very seriously. Sexual assault and domestic violence are some of the most serious accusations that we take in law enforcement, at least, but also within our regulatory institutions. That we have a way to, a transparent process and a due process to review the validity of that accusation and ensure that that physician or healthcare provider is not able to harm another person. We have cases in the state of Nevada where physicians have harmed up to 45 people and are continuing to practice medicine, where they have been stripped of their ability, their ability to practice in hospital settings because they are bad actors who have harmed people in those settings, but they are continuing to practice under their own shingles, under their own signs. They're continuing to bill for Medicaid services, being supported by taxpayer dollars, because we don't have a process to remove that person's license in certain cases. It's very specific, right? This is a very specific scenario in which we have to develop a process that ensures due process, that ensures that we are not pushing physicians out of our community without assurance, right, that they are doing or a true bad actor in our community. We want to make sure there's a balance struck, right, of implications from scorned partners, right, that just want to harm another person, a physician or a healthcare provider, with against those of true accusations that have resulted in true harm. This bill attempts to find that, to ensure that the backstop is in place for the licensing boards. And in the language that's in front of you, it's just the Board of Medical Examiners. We've been working to expanding that to all boards in which a healthcare provider or a provider of health services can engage with a person, right? So that would include all of the boards under the health arts, which is, I think, is Chapter 629. So that's in the amendment, but to give them a backstop to say we have to develop this process to assure that if a victim comes forward and says, I have been assaulted, and that person is truly under an investigation that has a substantial amount of credibility, that we can suspend that license and revoke that license. I don't want to walk through the bill because there's kind of a substantial, that it's really going to change through this amendment, which we've been working on the last week, to address the concerns of law enforcement, to ensure that we are not over regulating how they conduct these investigations, but also to ensure that there's a process to go forward where boards and law enforcement are working together to ensure that they are doing what needs to be done to protect the public from people who are licensed to practice medicine. But there is one important piece that I want to talk about in the bill, and that is in section 1 sub 6, where currently in the language it says the board. We would expand this to any board that's under the health arts section. However, the language would be substantially the same. If the board receives a complaint that alleges that a physician, et cetera, whoever is providing that or practicing that art health under a licensing board, if proven, commits an act, if proven would constitute domestic violence or sexual assault, the board shall ask the person who filed the complaint if the identity of the person is known, if he or she wishes to pursue a criminal investigation of the allegations in the complaint. If so, the board shall provide to an appropriate law enforcement agency the information contained in the complaint and direct that person to, and to the best of the board's abilities, connect the person with law enforcement agencies. So this creates that initial connection with the victim. Would we see that your complaint constitutes a violation that is enforceable by law? Would you like to be connected through us to law enforcement to pursue a case against this person? Then the second piece that's important is in section 3 sub 2, and again, this is specific to the Board of Medical Examiners. We'd like to expand this to all the boards under Chapter 629. The board shall adopt regulations setting forth circumstances under which the board, in response to a complaint filed with the board, is required to summarily suspend the license of a physician, et cetera, whoever's licensed under that board. Pending the conclusion of a hearing to consider a formal complaint against the licensee. Such recommendations may, without limitation, require the board to summarily suspend the license of a licensee in response to a complaint alleging that the licensee committed certain acts specified by the board, a certain number of complaints filed against the licensee over a certain period of time specified by the board, or any combination of the circumstances provided in paragraph A and B. It was important to me to include the establishment of regulations to define this process, because I think the transparency of the process is a problem for victims right now. They submit a complaint and then it appears to go and be lost in the process, which is important, right? The boards have internal processes that are designed to protect physicians from wrongful accusations. That's important. But there's, in the event that a person has been harmed and is waiting for justice, it's important that there's a process that they can define and rely on to see what is going to happen to the person who has harmed them. And I think it's important that the board adopt these regulations because it needs to be a public process with input from those who are affected by the regulations. It's important to assess the integrity of the institution through that public process, through the input of those who may have been victims, by those who are physicians, by those who could be impacted by the potential negative outcomes of an unjust process, to define what this transparent process should look like and who accountability lies on. Now, the rest of the bill has changed dramatically. If you look at the proposed conceptual amendment, I kind of covered the first one. We are looking to the first point here, outside of the deletion of the entire bill, to move those requirements of the board up into Chapter 629, which includes all of the healing arts. The next bullet adds new provisions for the licensing boards under 629, so that would be the second piece that we talked about in Section 3, moving into 629, Chapter 629. Now, this third bullet is where we start to talk about how do we engage in a different way with law enforcement and these boards. In talking to law enforcement, I am not a lawyer, I'm not a DA, not a public defender. I have no expertise in this area, and it became very apparent that trying to establish in a 4-month period of time a process for communication between law enforcement, who has an obligation to the public, and the board of medical examiners, who has an obligation to the public, and also licensees, was near impossible. So this third or fourth bullet creates the obligation during the interim for all of these bodies to get together and work towards a goal. The goal being, what does our process look like to ensure that we are communicating and capturing these bad actors prior to, if possible, people being harmed or additional people being harmed? One of the things that I heard from folks who have been victims of this situation is they have pursued a solution through law enforcement, pursued a solution through the licensing board, and pursued a solution through medical malpractice. And all three have stalled out. And the physician, the accused physician, is continuing to practice, and the recourse has not, there's been no resolution for the patient, for the victim. In talking to the board of medical examiners, the law enforcement community, the goal is not to leave people hanging, right? That is never the goal in these situations. It's not to have no resolution in perpetuity forever, right? The goal is to find a way to create or to make victims whole, or at least support them and ensure that there is resolution at the end. We don't know how to do that yet because it's very tricky. We don't want to get in the way of law enforcement's obligations to their case, right, to their investigation. And we don't want to get in the way of the Board of Medical Examiners' due process. And so how do those entities work together to ensure that there's a process that is getting the information between the two parties that they need to ensure that the public is safe? So that is what this interim committee is designed to do. With that, I will be open for questions.
Senator Stone?
Thank you, Assemblywoman. I appreciate your presentation. And certainly in Section 2, I think you referred to it as Section 1, Number 6, I don't have a problem with an alleged case of misconduct referring a patient to a public safety agency. And I appreciate the spirit of what you're trying to do. You're trying to prevent somebody that maybe a sexual deviant from, exerting their power over patients and assaulting them. I appreciate that, and I hope we can get somewhere in this bill to help that process. But I am very concerned about making the medical board of examiners basically the judge and jury before a conviction. I mean, you want to potentially suspend a license of a physician based on a complaint, and you even mentioned in your testimony about a scorned spouse, wife, girlfriend. Once you suspend their license, you're ruining the reputation of that physician. Now, certainly if they are found guilty of these crimes, they deserve to never practice again. But if they're found innocent, they may go back to a practice that doesn't exist anymore, and you'd be devastating them, you would devastate their families, and if they're in private practice, they still got to pay rent, they got to pay employees, and then they got their patients questioning, is my doctor a sexual predator? You responded to, I think, an issue that I had also, is that you kind of isolated physicians, perfusionists, physician assistants, but we have other professions, marriage and family practice, counselors, registered nurse practitioners, psychologists, social workers that come into interactions. So I was a little worried why you're just isolating the physicians here in this bill. I will tell you that when we renew our professional licenses, at least mine, which I didn't renew. I retired, as many of you know, back in April. But on the application for renewal, it says right on my pharmacist application, says, have you been convicted of a felony? And if you have, what is the nature of that felony? So there is a reporting process that I'm aware of. I'm not sure how that transponds here in Nevada. I assume it probably does. But I would assume that there is a communication between the district attorney's office if they get a conviction for a sexual assault that a physician or other healthcare professional has been found guilty of assaulting a patient, that I'm sure there's some type of mandatory, I hope there's some type of mandatory communication with the respective board, and if there's not, certainly we need to make sure that happens. But my number one concern here is the due process, that a physician or anyone accused, for that matter, of any crime is entitled to due process before we strip them of entitlements that could hurt their profession, professional reputation, destroy their business if it is a false claim. So I don't know how you want to address that, but I think it's a very strong concern for me.
Sarah Peters, for the record, I absolutely appreciate that. And I remember when the Board of Medical Examiners went through the process of deciding how to address addiction with physicians, right? When a physician is arrested for a DUI or found accused of being under the influence during an operation, there is a process in place, and it was a long conversation, right, with the board on how do we address those situations while protecting and supporting our doctors so they don't leave the state or lose their credibility in the community. And so that is definitely top of mind, and I've spoken with the physicians groups and other groups about this particular piece. How do we ensure that there is a process that is as protective of the victim in both cases, right? Our obligation is to the public, our physician's obligation is to the health and safety of their patients. When we have someone that goes outside of that, we have to have a process too, though, right? So that is an imperative part of the regulatory process, and I'm open to suggestions on massaging this language into something that gets to the point of that the board has to have a process in place, that all the boards have to have a process in place to consider these specific situations in which there could be a serial rapist who is using the power of their position to harm vulnerable people, while also protecting the institution and integrity of the institution. But that was my goal with having this be a regulatory process. And I did work with the board on ensuring that was what we built out. I think, again, it needs to be developed with the input of the physicians, and with consideration to the scenarios that do occur within the industry. So again, I'm open to modifying this language to get to that point better, but that is the goal.
I appreciate that, and you mentioned the case of a physician operating under the influence of drugs or alcohol. That's a definitive. They're guilty. They had a blood test. Their blood alcohol was 0.08, and they're performing open heart surgery. That's certainly something that they should be admonished for and should have their license suspended or revoked. But we're talking about instances where something hasn't been proven, and so that's where I think there's an issue. And I'm glad to hear that you're willing to work with us and try to mitigate that, because again, the last thing I want to do is destroy someone's professional reputation that's taken them 20 years to develop based on a scorned person. Certainly, again, if they're found guilty of taking advantage of their patients, they should have their licenses revoked. In my concern, forever. It's fine with me, but I just want to make sure they have that due process. Thank you.
I appreciate that, and you're right. In the case of substance abuse, it often can be definitive, not always, right? There is a due process in place to review that physician's well-being and health and ensure that there is a potential opportunity for rehabilitation, et cetera. And that's where this issue diverts, right? When you have someone who's a sexual predator, they should never practice medicine again. We should not be putting them back in a position of power to harm people. But it is incredibly difficult and I've talked to several victims who have alleged this occurrence. It's incredibly difficult to prove, right, that on the operating table what has happened to that person, if there's not someone who has observed it, who's willing to come forward and say, this was not okay, it's incredibly difficult to prove that was, that person has been harmed. And I think that what happened in that operating room was in fact sexual assault and not necessary medical practice. And that is where I think the board has to make the determination of in what cases too many complaints coming in about the same thing, a time where they have to engage. Where is it that they maybe need to talk to law enforcement about the outside of operating room situations, complaints that have come in? And I talked to the DAs about what the process looks like for someone who submits a complaint. And there is some discretion on how far do we take that complaint, right? If we can prove or not prove that that the person's story is something we can corroborate as being an actual case against a person. And so sometimes those complaints end up just sitting there. And in both cases, the regulatory authorities and law enforcement should have the ability to look at trends of persons, right, related to complaints of these two specific scenarios, sexual assault and domestic violence, to assess whether that person is healthy enough, right, is reasonable enough, whether or not they are a predator that needs to be addressed. And I think that's the goal of the interim conversation, is how do we get there? How do we ensure that we're working together? I don't have a solution for that. It is severely nuanced, right? But that's part of the reason it hasn't been addressed yet, and it's part of the reason why this issue continues to kind of perpetuate in the industry. I had one more thing, Sarah Peters, for the record. I wanted to respond to your suggestion of the self-reporting. We talked about that as well. I talked because law enforcement suggested the same thing. Is there a way to self-report? And then we started thinking about the cases that we're looking at, right? When you are a predator who is taking advantage of vulnerable people, the idea that they would self-report is not reasonable. That the reason why they abuse power is because they think they deserve to be able to do that, because they think they can get away with it. It's not the same as like a potential DUI or other addiction issues, but we've worked really hard to bring down the stigma on those as well. So it's just a different scenario, I suppose, on the kind of act that's occurring and the reason why.
Thank you, Senator Buck, Senator Scheibel, and then Senator Daly.
Thank you, Chair Spearman. I agree with my colleague from Senate District 20, and I wanted to ask legal, what is the constitutionality of summarily suspending license pending hearing?
Thank you. So there are a summary suspension of a license is generally authorized under the Due Process Clause when there is a danger to the public. And you would have to have, so if there is found to be, a serious danger and an immediate danger to the public, generally licensing boards could, suspend a license. There would have to be a hearing within a short time to address whether the suspension should continue, whether the violation happened, and whether the suspension should continue. But the process would be that when there is a serious and imminent danger to the public, the license could be immediately suspended, and there would need to be a hearing before the board within a short amount of time to determine whether that suspension would continue.
Thank you. Madam Chair, if I may, Sarah Peters for the record. I have had conversations with several representatives of boards in this building, and I believe that time frame is up to 45 days.
Senator Scheibel.
Thank you. I have a couple of comments and then a couple of questions. I really like this bill. I do think that it's important, and I think that we recently had a case in Clark County where a physician was assaulting patients in the context of providing medical care, and he was prosecuted for that. And I also like that we're setting forth regulations that are going to be consistent, because I've also seen in representing my clients in criminal cases that different boards have different approaches, but when a board does not have a clear regulation or clear rules about what is supposed to happen, that is when things get really dicey, because you have one doctor who might be, pending a preliminary hearing on a sexual assault case, and another doctor who has agreed to take negotiations but hasn't entered those negotiations, and they might get treated differently by different people at the board because they, interpret the status of the case differently, or because they happen to go through a different person who is physically reviewing the file. And so I think that for due process, it's very important that we say that these particular acts will result in suspension of your license. These particular acts will not. These particular acts require a hearing, and so on and so forth, so that doctors who are accused of these very serious crimes know what their rights are in terms of protecting their license. And so I think that providing regulations is the right way to do that. And my main question, though, is very general. I'm just a little bit confused whether the bill is supposed to pertain only to their conduct in the scope of their practice of medicine or outside of that.
Sarah Peters for the record. That is a really good question. And it's one that I think the judicial branches have struggled with as well, right? As well as the boards. And what is there, in conversations related to physicians, when you are a licensed physician, you have an obligation to the public. And so anything you do outside of the operating room and inside of the operating room is under the oaths that you take. Maybe that's not the same case for all boards, but if you have the authority and power given to you under a license as a healthcare provider, these actions in or out of a facility, healthcare facility, I believe should be reviewed, but I would suggest that determination would be made by the boards through their regulatory process.
So in that case, I'm still a little bit confused about the inclusion of domestic violence, because except in a very rare case where you have somebody treating a member of their own family in an office setting, domestic violence would occur outside of the doctor's office, outside of a hospital setting. So when I read domestic violence in this bill, I'm envisioning, and I want to know if this is the intent or not, I'm envisioning a case where, maybe I am in a dating relationship with the physician, that physician abuses me, I feel like I can't come forward because of her position in the community, because of her reputation, things like that. And so you're trying to provide a pathway for me to report to not just law enforcement, but to her licensing authority. Hey, you should know that there's somebody practicing medicine in the state of Nevada who, behind closed doors, is violent and abusive. And I'm wondering, is that the purpose, or am I missing the point?
Sarah Peters, for the record. We went back and forth on domestic violence. I did with legal staff quite a bit. So I wanted to include physical assault, and because that can occur, right? And it's like it can be outside of the sexual assault arena, right? And the suggestion was to encompass domestic violence because physical assault falls under the domestic violence. And again, I'm not a lawyer, so I'm leaning really hard on people who know more about this than I do. But that is part of the reason that we have included that. I think that, though, the case you talk about, the example that you gave, was something I had thought about and is something that I have heard in the scope of the conversations we've had with victims and other people who are willing to come forward and talk about the physicians who are harming patients, at least. So they do have often history with domestic violence, and that is often reported to law enforcement, not to the Board of Medical Examiners. So this is where the communication between the board and law enforcement is important, right? Is that you can start to create that profiling, right? The profile of the physician's actions. Are they a violent person? And do they still deserve to be practicing medicine as a violent person?
Sorry, just one more follow-up. And I completely agree. And I think that, providing ways to address domestic violence outside of the criminal legal system is actually very important because, not every problem can be solved by criminalizing people and by prosecuting them. And I don't mean to put you on the spot because I do not know the answer to this question. And I don't know, maybe our policy analyst can follow up, but I'm curious if there are other analogous boards, governing agencies where a victim survivor can report, abusive behavior to that person's professional board. And like specifically, I'm thinking about other people, like you said, who have an obligation to the public, teachers, first responders. Those are the two that first came to mind. And I don't know if that hypothetical, which by the way is not true, if that hypothetical that I described were with a teacher instead, would I be able to report a teacher's abusive behavior at home to the educational licensing board, and would we want to be able to do that? So maybe that's more food for thought than a question, but I think that it's part of my consideration in evaluating the strength of the policy.
I don't have Sarah Peters, for the record, I don't have a response for you on that. I am not, this is my first dive into licensing boards, really, outside of just knowing some based on my family's history and involvement in the Board of Medical Examiners specifically. But there are some folks in the audience who represent a variety of boards who may be able to respond if that is of the interest of the committee.
Sure, please go ahead if you have someone.
Thank you, Madam Chair. Madam Vice Chair. For the record, my name is Tom Clark. I am here on behalf of the Board of Medical Examiners. It's important to note that the Legislative Subcommittee of the Board of Medical Examiners meets next Friday. They have not been able to take a position on this particular amendment. If I can answer a question, I will. I can also phone a friend if necessary. Senator Scheibel, if you don't mind repeating the question.
I also don't mind following up offline because I know that we do have a lot to get to. I just want to make sure that we're not setting up a system where we, just by nature of being a doctor, somebody is subject to some additional penalties for the same behavior that other people also engage in. Basically, what I'm asking is, are there other boards where if you have an obligation to the public and there is reason to believe that you are unsafe, you're violent, you're a danger to the community, that people can report that to your licensing board or professional board outside of just medicine?
Thank you, Madam Vice Chair. Michael Hillerby. Senator, on behalf of the Nevada State Board of Pharmacy and Nevada State Board of Nursing, there are specific offenses in each board's chapter, and those can, in fact, have little to do with the actual practice of nursing or medicine or pharmacy that we would be interested in, that licensees are required to report, or if we get that information from law enforcement or another source, we would look at and can potentially be a source for discipline. If you are for example, I use the example a pharmacist, and we find out somehow outside of your job you are trafficking in drugs or using drugs or habitually intemperate is the language in the statute, you're going to have some explaining to do to the board because in your day job you're handling the controlled substances in a pharmacy. So there are a variety of things and those differ by chapter. And I do want to go back to the answer Mr. Fernley gave. You're correct. NRS 233B 127 governs summary suspension, and as the Assemblywoman said, it is 45 days. So if you do a summary suspension, which all boards and commissions and other agencies can do of a license, you do have 45 days to institute and complete proceedings to make a determination. So again, the Assemblywoman, I think, has done a good job of pointing out the delicate balance that the law creates between protecting the public and the rights of the accused. So working through that is going to be somewhat complicated. If there is a criminal investigation going on at the same time, that's unlikely to be done in the 45 days. So, and talking with the Assemblywoman, would suggest that perhaps a lengthier effective date for the regulatory part, so we could spend some time with the AG, with law enforcement, other attorneys, other experts, crafting something that could be somewhat uniform across those boards, as I think you suggested, so that that's handled correctly, so that both parties have their rights protected and the state's not finding itself in the crosshairs of a lot of lawsuits that could get expensive. Thank you.
Thank you. I just want to say that does answer my question. It also assuages my concerns, and I agree that this bill does a great job of finding that balance point of protecting the public and also holding people responsible without, undue burden on the accused. So I think that you've hit the balance here, and I appreciate you guys coming up, impromptu. Thank you, and answering my wild questions. So thank you.
Thank you, Senator Daly.
Thank you, Madam Chair, and those guys may have to come back, I don't know. Similar concerns that you've heard across. I mean, the bill as written, I had concerns that you were going to put in regulation that you could suspend somebody on an allegation, which we've talked about quite a bit. I had a similar concern over the question that Senator Scheibel asked regarding the domestic violence, because, I mean, that's usually outside the setting unless it's a relative there where you're at. And that I think there's a distinction there, not saying that it can't be a factor under the board and the licensing and various things. And I think Mr. Hillerby was saying that there's provisions where they can do these things if somebody's doing this, but I believe it's if they're convicted. There's been some proof of violation, and there's been an adjudication. And we're crossing over here into some of this of, the criminal. I'm not a lawyer either, but someone can correct me if I tell you something that's wrong here. But so when you're a criminal, the level of the proof is beyond reasonable doubt. We've all heard that for our whole lives, right? So that's a higher standard. If you're in civil or maybe under these licensing board, there's lower levels of proof. Clear and convincing would be next. Preponderance of the evidence, and then perhaps the lowest level is rebuttable presumption. We're going to say you're guilty, you prove you're innocent, and we want to avoid that. So I guess having laid out the concerns that you've heard here, I guess part of my deal with the amendment that you have is, what's the timing on some of this stuff? I think having the interim or the standing committees in the interim take a look at this, have a subcommittee, try to come up with, this is what you should put in the regulations as far as this goes, when's too far, when's not, et cetera, is useful. So are they going to adopt regulations before that work is done? Are we going to say, hey, you adopt these regulations after that work is done? Because I think there's an order of operations here that we don't want to get ahead of and have 20 different boards come up with 20 different ways to do one thing, and it's very sticky. You picked a hard thing to define because people are innocent until proven guilty. Allegations can be made, and suspending the license, as you heard Senator Stone say, can be very damaging without the allegations. But then there is also people that you need to protect on that. So I guess the timing is my really only the question, because it's a very difficult path to make sure you're not stepping on someone's due process rights, causing them to be harmed where they sue the board if their license is suspended, when eventually they're adjudicated innocent, or there wasn't enough evidence to proceed. You mentioned that the cases are put out there and you have reasonable doubt, and the district attorney has to say, do I have enough evidence to proceed? And if they don't, it's not that they just can't prove it, right? Lots of jogs in this puzzle. So
Absolutely. Sarah Peters, for the record, you guys are all going through the thought processes that we've been going through in our meetings of how do we strike this balance? How do we ensure that the boards have the backstop of authority that they need to potentially suspend a license without a criminal adjudication, because it can be so difficult to get that in these particular cases. However, you can see trends in which a person is a violent person who is acting outside of the best interest of the public. And so the responsibility of the board is a little different than it is in law enforcement, right? And upholding the institution in a different way. And I think that that's where my goal with the regulatory development is really to give the boards the opportunity to have this conversation, to go through the public process and the regulatory development process in which they have the discussion of what makes sense for us, what is our job in this process, and where do we have to draw the line when we can't depend on law enforcement to complete this process for us. And maybe they will come up with a scenario in which that's impossible. And that's another conversation that we should have about the integrity of the institution, the healthcare institution, right? Is what is their responsibility to the public if they rely on law enforcement to ensure public safety? That is a conversation that should be had as well, which I think will be part of that interim committee. I want to respond, though, real quick to your ask on the timelines. I was talking to Mr. Hillaby earlier this morning. Like I said, this amendment came in so late because we've been working throughout the process to iterate this in a way that works for everybody. His suggestion was to push the regulatory timeframe out to January 2025, which I'm open to, which would give us the opportunity, if it's just not happening, if we've come across stumbling blocks in which the statute isn't helpful in the regulatory development process for this particular scenario, that we can come back and address this statute if necessary. But I'm hopeful that the language that we've developed in this the regulatory development piece gives enough latitude while also giving enough backstop that we will get to a good place with regulations in that time frame.
And I appreciate that, and I think that is the path. I think it's also on the interim standing committees, and I know we changed that a couple years ago, so this will be my first interim under that new process. But I think that part will be critical to get the input of a variety of different people on various things. And I think if it goes through that process, and you can find a path, and that's still in doubt, right? We just don't know. That it's then put in place, and you're going to have all these different boards doing that. There's a relatively, or as most consistent as possible, uniform, if you will, regulation on what they're supposed to do, what are the steps, when they can take action, when do they have enough evidence, on what level that's going to be. Obviously, they can't go through the criminal process and the beyond reasonable doubt. That's not their purview. And then none of us here, I don't think, are judges, right? And eventually, they may be the ones making the final decision if we found that path or not.
Thank you. I think that's all the questions. You have any additional presenters? Okay. If you'll step back, then we'll open up public testimony for those in support. Here in Carson City and in Las Vegas, there are 3 chairs available in both places.
Good morning, Chair, members of the committee. For the record, my name is Serena Evans, and I'm the Policy Director for the Nevada Coalition to End Domestic and Sexual Violence. Today, I am here on behalf of numerous victim survivors who have allegedly experienced reproductive coercion, medical mutilation, and sexual assault at the hands of a prominent OBGYN here in Northern Nevada. I say allegedly, not because I don't believe them, but because of current pending investigations that have taken far too long to conclude any final findings. I want to thank Assemblywoman Peters for listening to the heartbreaking stories of these victim survivors and for taking action and bringing this bill forward. Our current system has seemingly failed victim survivors, which is why I sit before you today. NCE DSV was approached in the interim by a large group of women seeking justice against one particular doctor. This group of women has submitted more than one complaint filed through the Board of Medical Examiners claiming unnecessary procedures, sexual assault, botched surgeries, Medicaid fraud, and medical coercion. The horror stories that I heard made me sick to my stomach. These brave individuals shared with me that they tried to pursue action through law enforcement, but were told that they do not have jurisdiction, and that their complaints through the board have taken an uncomfortable amount of time for review, despite multiple complaints for the same issue against one doctor, including sexual assault. All the while, this doctor is still practicing and likely harming low-income and marginalized communities. Just this week, there has been in headlines a similar situation with a Las Vegas OBGYN accused of sexual assault and harassment in the pending disciplinary hearings. We are taught to trust our doctors, but these situations are a blatant abuse of power and control, and there must be accountability for stopping ongoing harm. Excuse me. Many of these victim survivors want to share their stories, but because of the vulnerability of their experience and the power that these high-profile doctors have in our community, they are fearful of sharing them on public record. And on behalf of those too fearful to speak here today, we urge your support and passage of AB 442. Thank you.
Good morning, Chair Spearman and the Senate Committee on Commerce and Labor. My name is Chris Reese. It's R-I-E-S, and I represent the Las Vegas Metropolitan Police Department. We support AB 442 and the proposed conceptual amendment. We appreciate Assemblymember Peters and her leadership on this very important issue. We're looking forward to working with her and the committee during the interim and continuing our relationship with the Board of Medical Examiners as well. Thank you.
Thank you, Chair Spearman, members of the Senate Commerce and Labor Committee. My name is John Jones, and I'm here on behalf of the Nevada District Attorneys Association. We are in support of AB 442 with the amendment. And I, too, want to thank Assemblymember Peters for bringing us into this conversation early. It is a very important conversation to have, and we are fully behind the intent of the bill. But I do want to say, like addressing Senator Stone's question, I, as a DA, don't always know that I'm dealing with a physician when I have a defendant standing in court with me. We do, as we go through the process, get more information about them. We ultimately, if they are convicted, have a PSI, a pre-sentence investigation report, but a lot of that is self-reported by the defendant. So if the defendant takes the opportunity to conceal the fact that they're a physician or other licensed professional, I as a DA may not know that unless the crime is particularly related to their line of work. So that's one of the issues that I think we're going to try to work on in the interim, is to figure out how this process will work. I will point out that with respect to teachers, with respect to juvenile probation officers, and with respect to child welfare workers, there is a statutory process in place that deals with license, or not necessarily license, but suspension while the process is working itself out. And maybe those are statutes that we can look at for guidance in this area as well. But with that, I want to thank again Assemblymember Peters. This is an important conversation, and we're looking forward to having it.
Good morning, Chair Spearman, members of the committee. Jason Walker, Washington County Sheriff's Office, testifying in support of AB 442 as amended. Again, thanking Assemblywoman Peters for including us in these discussions. There have been many meetings and discussions getting us to this point. As a member of law enforcement, I would have no issue in participating in a working group to study any issues relating to the sharing of information between law enforcement agencies and licensing boards.
Good morning, Chair Spearman and members of the committee. For the record, my name is Pamela Del Porto, DELPORTO, and I'm Executive Director for Nevada Sheriffs and Chiefs. I can just say ditto, but I just want to stress that we are in strong support of the bill as amended, and thank Assemblywoman Peters for working with us. Thank you.
For the record, my name is Andrew Pasternak, ANDREWPASTERNAK. I'm a family physician in Reno. I'm here representing the Nevada State Medical Association as past president and testifying in favor of AB 442. The Nevada State Medical Association is Nevada's largest and oldest physician organization. When the the Nevada State Medical Association was here on our Doctors' Day about a month ago, I got to meet with Assemblywoman Peters about this bill, along with some of my colleagues. And we really want to thank her for listening to many of our suggestions. As a physician, I take an oath to serve my patients. On a grander scale, the Nevada State Medical Association is here to advocate for our patients. When it comes to situations such as the one that Assemblywoman Peters described, we want Nevadans to be protected. No one wants bad physicians out of practice more than good physicians. Bad physicians undermine the trust that the public puts in Nevada's physicians. We'll continue to work with the sponsor to make changes to continue to improve this bill on this very important issue. Thank you for your time.
Hello, my name is Hannah Fahmy, HANAFAHMI. It terrifies me to be up here. I do not like it. And I'm on my own behalf. The reason I'm in this room and in this building every day this session is because I moved here to be closer to my grandma. And in doing that, when I got to Carson City, jobs here are very limited on what you can be doing. And I had an amazing opportunity to go to Saunders CNA training to become a CNA, learn how to take care of my grandma, as well as work in a facility and gain my skills and get a certificate. Unfortunately, I had to report a scenario, and there was many scenarios that should have been reported. That led to my departure at a place that I was really good at, something I really enjoyed. And at the time, I don't know how things could be changed. So, Pat Spearman, when you said you made a point about accountability today, and then hearing this bill come up, it's so important. There's programs that y'all are putting in place that are brilliant. My teacher, Kaz Gilbreth, was brilliant and made me want to do this work. But I get into places that the environment is not that. And this really is something that I think could help a lot. So I appreciate y'all hearing me out today, and thank you.
Anyone else in Carson City? Don't see anyone down south. BPS, is there anyone else on the phone?
If you would like to testify in support of AB 442, please press *9 now to take your place in the queue.
Good morning, Madam Chair
and the committee. This is Dora Martinez, representing the Nevada Disability Peer Action Coalition. We want to thank Assemblywoman Peters for sponsoring this bill and bringing this bill to your attention. And people with disability are very vulnerable, and we are part of the victims as well. So please support this bill, and thank you so much. Have a good day.
Public line is open and working. There are no callers at this time.
Thank you. We'll move now to testimony in opposition. See anyone moving here? No one moving in Las Vegas. BPS, anyone else on the phone?
If you would like to testify in opposition to AB 442, please press star 9 now to take your place in the queue. Public line is open and working. There are no callers at this time.
Okay, we'll move now to neutral. Anyone here in Carson City? Anyone in Las Vegas? Yes, sir.
Thank you, Madam Chair, members of the committee. My name is Tom Clark. I am here on behalf of the Board of Medical Examiners. I really want to say thank you to Assemblywoman Peters for bringing forward this bill. We have had lots of conversations over the last 100 days or so about this very important issue. We know that there are bad doctors, and we know that there are victims, and we know that there's due process, and all of the things that have been discussed today. I'm in a neutral position simply because our legislative subcommittee of the Board of Medical Examiners has not had a chance to review this amendment. It is consistent with a lot of the conversations that we have had. We meet next Friday, and we hope not only will this language be fully vetted by then, but any additional changes to that, and we hope to come to the table in support, or if they change their minds, we'll come up in opposition, but I have to be in neutral today. Thank you, Madam Chair.
Thank you. BPS, anyone on the phones?
If you would like to testify in neutral for AB 442, please press star 9 now to take your place in the queue. The public line is open and working. There are no callers at this time.
Thank you, Assemblywoman. Closing comments? And just want to say to the young lady who came to take care of her grandmother, we hope that she's doing okay. And so let me just make some closing comments. I'm not sure what the happy medium is for this, but as I listen to the testimony, it's a trigger for me because it sounds so much like some of the women who are suffering from MST, military sexual trauma, in which they are assaulted, and because they're the person who did this to them is a superior, and they have no place to go. So I would encourage the subcommittee to look at all things, and I'm not sure what other states do, but this is an issue, and we have to solve it. That's what we're supposed to do as legislators, so thank you all for coming forward. And again, I heard the train that's going south, inviting those persons who are guilty of these types of crimes to jump on board. And those of you who've been here for a while, you know what I'm talking about. So, thank you. Okay, thank you. With that, we'll close the hearing on Assembly Bill 442 and open the hearing on Assembly Bill 364. Assemblywoman Cohen revises provisions governing physician assistants.
Good morning, Leslie Cohen, Assembly District 29. Thank you for hearing Assembly Bill 364. I'm going to be really brief in some opening statements so that you can hear from the most important people on this bill, physicians' assistants. And I know you've had a long morning, so let me just get started. As you know, Nevada, like states across the nation, is grappling with a healthcare provider shortage. Healthcare providers in Nevada are retiring, especially in family practice and primary care, and physician assistants help fill this void in our healthcare system. Physician assistants are advanced practice allied health professionals who are nationally certified and licensed in Nevada through the Board of Medical Examiners and State Board of Osteopathic Medicine. Before they can earn licensure, PAs undergo rigorous education and training as medical professionals. So with us today is Dr. Brian Lauf, who grew up in Reno and attended Hug High School, Truckee Meadows Community College, and University of Nevada, Reno, and received PA training from Oregon Health Science University and the University of Nebraska Medical Center. He earned his Doctor of Medical Science with an emphasis in education from the University of Lynchburg. He has been a PA in Nevada for over 25 years and a two-time Nevada Health Service Corps recipient. He is an associate professor and founding PA program director at the UNR School of Medicine and devotes his time to training and education and educating aspiring PAs to serve in our communities. Also with us is Carmela Downing. She's a PA at Carson Tahoe Health and has worked in cardiology for 15 years. She manages the Congestive Heart Failure Clinic and is the Advanced Practice Medical Director for Carson Tahoe Medical Group. And then additionally, we have John Sandy, who you all know. And then Chair, I do have a quick walkthrough of the bill after the presentation from the other parties is done. If you'd like me to do the walkthrough, I can do it. If you don't want me to, it'll just be your choice, and you can let me know at that time or let me know now.
Can you do a brief walkthrough? And that way, if committee members have questions, your walkthrough may answer those.
Okay, and then I'll just wait until after they provide their part of the presentation, if that's okay.
Thank you, Madam Chair. For the record, John Sandy, here today representing the Nevada Academy of Physician Assistants. As you can see, this is a hefty bill as far as pages go, but I think it can be summarized pretty quickly. And what I figured I'd do with my time is to try to offer what exactly we are trying to accomplish with this bill from a 30,000-foot perspective. And I'm going to do that by illustrating some of the amendments that we've agreed to really clarify what the intent of the bill is. Now, the first part is a little less controversial, so I'm not going to really address that. The second part is really kind of the meat of what I'd like to get into. And there seems to be a disconnect between what we're trying to accomplish and what our opposition believes we're trying to accomplish. So the stated intent, and this is in the documents that are on Nellis, but what we want to do is bring decisions regarding the optimal team practice to the practice level rather than the board level. So now, this stated intent might be really clear when you're a health professional practicing daily, like Dr. Stone. However, when you're like me, you hear those words and they are kind of hollow. So I wanted to start by describing what we're trying to accomplish in more layman's terms. So under the current system, when you're a PA that graduates, the law says that you have to enter into a supervisory agreement with a physician. And under the requirements and the regulations, that essentially requires you to meet with that physician for 4 hours a month and that you submit paperwork to the board. I hesitate to use this, but it's almost like performing surgery with a butter knife. It doesn't take anything about the PA's practice, where they practice, how they practice, who they practice with into consideration. It just says broadly, supervisory agreement, 4 hours a month. So we think there's a better way. And so to start, I'm going to say that better way, what we're not trying to do. And I can't emphasize this enough. We are not trying to seek to have PAs practice independently. Not requiring a supervision agreement does not mean that PAs will be working independently. It means that PAs and physicians won't need to fill out that piece of paper each month in order to for that PA to continue practicing. We're also not trying to seek to create pop-up PA clinics. That was a big concern we heard kind of in the assembly was, well, we're going to have pop-up PA clinics everywhere. So there's an proposed amendment in Nellis that we say that if you're not a facility that pretty much has doctors around, a facility that's owned by doctors, essentially any facility that's a medical facility that is owned by PAs or somebody that's not licensed to practice as a doctor, then you need to continue having under the current system. And we're totally fine with that because, again, that's not our intent to create that. We're also not trying to create are trying to prevent hospitals or clinics from implementing their own requirements regarding how PAs practice and how they're supervised. In fact, this is exactly what we're trying to accomplish. That's what it means when we bring it to the practice level, the optimal team practice. So if a PA is practicing in a complex field of medicine, maybe they need 18, maybe 16 hours a month. Maybe they need more than one supervising physician. This should be the decision that's made at the practice level, not at the board level, an arbitrary. This is where I say this is more like using a scalpel. Let's really hone in on what that PA is practicing in and create the situation that's going to allow them to flourish with the doctors and the other healthcare professionals that are working in that system. Now, if you're practicing in an area like my wife practices for renowned medical groups. She practices in primary care. She's probably the smartest person I know. In fact, we have a lot of doctor friends, and I know for a fact they come and ask her questions about how they're treating. But regardless, they have cubicles right next to each other. She practices day in and day out. She might not need to do this arbitrary 4 hours and meet with them and send paperwork off to the Board of Medicine. Maybe she needs every other month. Maybe she needs every 6 months. I don't know. That would be a good thing for Renown to decide, but not for us to create an arbitrary standard at the board level. So again, what we're trying to do, and I want to make it clear. So a stakeholder came to us, approached us 2 days ago and said, well, we're concerned that this bill is going to limit our ability to create that situation for, we own a clinic and we have our PAs working under supervisory agreements. Some have 2 supervisors, some don't. We're not trying to mess with that. And so we're working on language that will clarify that that is absolutely not our intent. So what are we trying to do? Again, the point of this bill is that these decisions are best left at the practice level. Again, not an arbitrary requirement set by the board. Also, to point out, I think it's worth pointing out that, and I think the PAs that are here to testify have a really good insight on this, is that PAs are currently at a disadvantage when compared to APRNs. In 2013, APRNs passed a very similar bill to what we're trying to pass today, and did not pop up our just APRN clinics. They're not practicing in a collaborative environment in a clinic. They're still under collaborative agreements, all of this. And so I think what we're proposing is not as scandalous or as provocative as it might be made to seem. What we're really talking about, in my opinion, is very straightforward and commonsensical. And so with that, I will turn it over to the PAs can explain their practice and their education at a much more granular level. Thank you.
Good morning, Madam Chair and members of the Committee on Commerce and Labor. Thank you for the opportunity to present AB 364. For the record, my name is Brian Lauf, B-R-I-A-N-L-A-U-F, and I'm here representing the Nevada Academy of PAs, also called NAPA, in support of Assembly Bill 364. As mentioned, I'm an associate professor at the School of Medicine, and I'm the founding program director of the PA Studies program. However, I'm not here in that capacity, and the University of Nevada, Reno does not have a position on this bill. I've been a PA, as mentioned, for over 25 years here in Nevada, and I've served twice as the president of the Nevada Academy of PAs. Today, I want to discuss 2 points. One, the education, qualifications, and licensure of PAs, and 2, the benefits of modernizing PA practice to better reflect the current healthcare models and the collaborative practice PAs and all members of the healthcare team. NAPA is a professional association for the PAs in the state of Nevada and aims to improve the access to quality healthcare and give a voice to the PA profession through education and advocacy. With over 1,200 PAs working in every facet of the state's healthcare industry, we are committed to delivering high-quality healthcare to all Nevadans. First, I will discuss the education and qualifications of PAs. PA education is at the graduate level, that prepares graduates to be medical providers who diagnose, treat illnesses, prescribe medications, and much more. Acceptance to PA school is highly competitive. In my program last year, we had over 1,400 applications for 24 seats. Our overall program acceptance rate is 1.7%. The average applicant to PA school brings with them over 6,000 hours of working healthcare experience. With an average age of 27, PA students also begin their training with broad and diverse life experiences. For example, I began my career as a medic in the United States Air Force, where I received extensive medical training prior to entering PA school. After separating from the military, I returned home and attended Truckee Meadows Community College, earning an associate's degree in science. I attended UNR, where I studied molecular biology prior to being accepted to PA school. Following my primary PA education, as mentioned, I also completed postgraduate degrees at the University of Nebraska and my doctoral degree at the University of Lynchburg. PA students undergo rigorous training at the graduate level to include 123 credit hours, 2,000 plus clinical hours in multiple medical and surgical disciplines, including emergency medicine, surgery, family medicine, pediatrics, internal medicine, women's health, behavioral medicine, medically underserved populations, and elective rotations that may include subspecialties such as cardiology, endocrinology, and urology as a few examples. After graduating from an accredited school, PAs must pass a comprehensive national board certification, which is also a requirement for licensure in Nevada and across the nation. To maintain our license, we must complete over 40 hours of continual medical education every 2 years while staying current on medical innovations and best practices. To maintain our board certification, we must complete 100 hours of continuing medical education every 2 years and pass our national board exam every 10 years. We must complete training to maintain our DEA license to prescribe controlled substances. The standard professional liability insurance in Nevada for PA medical malpractice coverage is the same as physicians, $1 million per claim and $3 million per annual aggregate. Next, I'd like to address why we're here discussing this bill, modernizing PA practice to reflect models of collaboration. There has been a lot of thought and discussion about the best manner to improve access and care by providing more flexible practice arrangements. I am confident you are fully aware that Nevada is at the bottom or close to it on multiple healthcare measures, namely access to healthcare. The issue is worsening, and PAs are here to help address this trend and perhaps turn it around for good. Research indicates that the most up-to-date practice laws allow healthcare teams to decide at the practice level how they will best collaborate and meet patient needs. The best evidence also demonstrates that the most successful clinical teams are those that fully utilize the skills and abilities of each team member and support efficient, patient-centered healthcare. The key word here is team. Let me dispel the myth about independent practice. Despite what people believe, right or wrong, today's healthcare system is effectively without independent practice. There are numerous types and levels of regulatory and policy-driven oversight and vast data that create transparency into the efficacy, efficiency, and safety of a clinician's practice. The bottom line, the supervision of PAs currently outlined in NRS 630 and 633 is far less than the required oversight in medical practice settings, but a significant administrative burden and barrier for PA practice and patient access. PAs, like physicians, are most often employed by hospitals, medical groups, or other facilities. These facilities, as outlined in Section 4 and 23 that we have mentioned, addressed where PAs are authorized to practice and have supervision and oversight requirements for all employees to ensure patient safety and mitigate liability. Oversight may include granting privileges, credentialing requirements that allow a PA or others to work in certain units, perform certain procedures, and other types of services authorized to deliver. AB 364 removes the supervisory burden from the Nevada PA Practice Act, allowing clinics and hospitals greater flexibility in assembling healthcare teams to meet patient care needs. The more collaborative and interdependent practice arrangements enacted or currently being considered in several other states has provided greater agility in meeting healthcare needs, especially in our rural areas. You will hear physicians say, perhaps even today during testimony, it's about patient safety. I have pages of peer-reviewed literature to speak to the safety and efficacy of PA practice. I'm happy to provide. In response to the COVID pandemic, governors of 8 states removed supervision requirements for PAs, and another 13 did so through previous legislation specific to PA practice. During a public health emergency, what happened in these days and what have we learned? PAs did what they were trained to do, serving where they were most needed, and the result has been greater healthcare access and continued excellent outcomes for all patients. It is not surprising, but perhaps less known, several branches of the federal government, including the military, the VA, the Indian Health Service, that have long ago removed physician supervisory requirements for PAs and recognized their ability to practice safely in various settings. All right, I got my pages mixed up here. In thousands of different practice settings and assignments at home and abroad, military PAs serve in combat, at the White House, and provide comprehensive, high-quality care to thousands of military members and their families. Nevada PAs greatly respect the breadth and depth of physician training and are proud to practice alongside them every day. Our practices and patients benefit from this team approach when it's defined at the practice level. It continues to be the position of NAPA that there is room for all healthcare team members to practice to the full extent of their education, training, and expertise. As practicing PAs, we currently do and will continue to work closely and collaborate with physicians on the healthcare team. We stand by our historical relationship and devotion to team practice with physicians and all members of the healthcare team. At UNR Med, we have spent the past 7 years planning, building, and executing the state's only PA program in a public institution to meet the healthcare needs of Nevada. With the modernization of PA practice laws in neighboring states and across the country, we are at risk from becoming an exporter of this valuable resource. Nevada has experienced this with other health professions. Let's avoid repeating this with PAs. Providing favorable and safe practice laws will allow Nevada to keep this critical resource. In closing, I want to thank the sponsors, Assemblyman Cohen and Assemblyman O'Neill, and several co-sponsors for bringing this bipartisan legislation forward and continuing their work to progress the healthcare system in the state. I respectfully ask this committee to support AB 364. I would be happy to answer any questions, and thank you for your time and consideration.
I'd like to thank the chair and the committee, as well as our sponsors and multiple co-sponsors for this opportunity to speak today. My name is Carmela Downing, C-A-R-M-E-L-L-A, last name Downing, D-O-W-N-I-N-G. I'm a physician assistant working here in Carson City and a representative of the Nevada Academy of PAs Legislative Committee. AB 364 is about the transparency of our current practice within healthcare teams, modernization of outdated language regarding the relationship between a physician and a PA, and the representation of PAs by the medical board which govern them. Nevada is the only Western state that does not provide representation of PAs on the board licensing them. I would like to give a couple examples how PAs are a vital part of the healthcare team. I help design and now manage the congestive heart failure clinic at Carson Tahoe Health. Most patients are seen weekly in the month following discharge from the hospital. Readmit rate within 30 days for heart failure patients at Carson Tahoe was the national average of 23%. Since the start of the clinic, we have averaged 11%. First quarter of 2023, 9%. Having a PA manage these visits has enabled more patients to be seen quickly, and thus minimizing unnecessary ER visits and costly hospitalizations. My training as a PA, the collaboration with my physicians, fellow PAs, and nurse practitioners gave me the knowledge and experience to make this happen. When I first started on the recruitment committee at Carson Tahoe Health, we reviewed candidates for an urgent care position. An experienced PA was passed over due to the lack of available supervising physicians to sign an agreement with the state. We did not have enough physicians to meet the needs of our patients, the volume, let alone have a physician to supervise another PA. We don't have enough providers in Nevada, particularly physicians. To keep up with the demands of our state, we are neglecting our rural and frontier areas due to burdensome administrative constraints. Fortunately, our neighboring states have implemented an environment where PAs can practice to the full extent of their medical training, education, experience. Additionally, Nevada is the only Western state that doesn't allow representation on the boards. PA Advisory Board that has been created for the Nevada State Board of Medical Examiners does not allow a PA to vote on professional matters. PAs need meaningful input on the regulation of the profession. There needs to be an expert voice on current knowledge of the profession when regulatory boards make decisions affecting its licensees. AB 364 asks for PA representation on the board. Nevada has suboptimal PA practice landscape. Utah and Wyoming have passed similar legislation found in AB 364. Arizona and Montana both passed bills this year to modernize PA practice. While I'm excited for these states and how it can improve practice, I'm concerned about our state if we do not improve to get the clinicians we need. How do we expect to address Nevada's issues regarding access to health care without modernizing the regulations that stagnate the ability to hire PAs and their ability to care for their patients? Nevada has fallen behind and will continue to fall behind if we do not modernize our legislation. I appreciate your time and consideration, and I humbly ask for your support of AB 364.
I'd like to thank the chair and the committee for allowing me to testify on behalf of 364. My name is Dr. David Baker. I'm a cardiologist. I've been practicing cardiology in Carson City for about 17 years. I'm also the vice president and chief medical officer for Carson Tahoe Health. And I strongly support this bill on several grounds. The first is clinical. So I have practiced cardiology for about 20 years. I've done so with physician's assistants and nurse practitioners in a collaborative agreement, a collaborative kind of system, which has been of huge benefit to myself professionally and to the health of our communities. I work with Carmela. I'm her collaborative physician. We developed the heart failure clinic, and I say we because I did about this much and she did about that much. I'm also working with Kenny Larson, who is here, who is running our COPD clinic. These are two clinics that take very sick patients with life-threatening diagnoses coming out of the hospital. They've been recently decompensated in their health systems or in their health concerns, and we concentrated them into these clinics. The clinics have been massively successful, and they're run by PAs. So they have decreased the readmission rates. They've kept patients out of the hospital. Patients benefit, the hospitals benefit by not having to incur those costs or penalties that come along with increased readmission rates. I also care for probably 4,000 or 5,000 general cardiology patients in my clinic. I do so with the help of a nurse practitioner, another APC, that helps extend what I can do. I could do none of this on my own. I could not even begin to run these clinics on my own. I need physicians' assistants and nurse practitioners to do so. I've been able to do so for 20 years at a very successful manner. My second role is I'm also an administrator, so I helped form and manage Carson Tahoe Medical Group for the past 12 years. We started off in 2010 with about 10 or 12 providers, and I think 2 of those were PAs. We're now up to about 115 providers. About half of those providers are APCs, nurse practitioners or physician's assistants. There is no way we could even begin to cover the healthcare needs of Carson City without our assistants. No way whatsoever. There are simply not enough physicians out there to do so. I don't know of any other groups in town, private groups, that don't have PAs and nurse practitioners to help extend them and provide the care to the community that we need. Simply not enough doctors. It takes too long to make us, it's too long to turn physicians over to clinical practice. And so the PAs are essential for our ability to care for our community. Last thing, so I know there are some opposition to this bill from physicians. Seems to center on the fact that there is clearly a difference in education between PAs, nurse practitioners, and physicians. PAs are extremely well trained and schooled. I did a lot more than what they did. So that is why I think the collaborative agreements are huge. because you can work together in that team model, take care of patients, provide a high level of quality, and extend that service out to many more people than I could do on my own. So if there's any other questions or anything, I'd be happy to answer them, but I'm strongly in support of AB 364. I thank you for your time.
Thank you. Committee? Senator Daly?
Thank you, Madam Chair. And I know several of you came and talked to me. I know I talked with the Assemblywoman a little bit, and I'm still just trying to work through it all, and I'm sure you guys will come talk to me afterward. But looking at the amendment, real quick, changing the two things, just a couple of questions so I understand. So it says you're going to have a collaborative agreement with physicians if the physician assistant work in a clinic that is not traditionally staffed or owned by a physician. So begs the question on the other side, because I'm not familiar. So what happens if you're in a facility traditionally staffed or owned by a physician? Is there still the collaboration, or are you changing something? And I know you took out the part that you don't have to be supervised, and I heard your testimony on some of the stuff when we talked. So what's the distinction there that we're trying to get to with the amendment?
Madam Chair, it's exactly what we're trying to do. We're trying to
Your name?
give, sorry, for the record, Brian Loff, exactly what we're trying to do, and I appreciate the question. We're trying to be able to allow facilities to make that determination. So yes, to your question, yes, it will determine the level and how a physician and a PA work together will be determined at that particular site or any of the other locations listed in that section. Does that answer your question?
Yes, on that level, but come follow up with me. But yeah, I just wanted to make sure I understand what happens now and what this is going to allow, and then what the amendment is going to put in an additional step.
Senator Pazina?
Thank you, Chair, and thank you for the presentation. So are practices required to have this collaborative agreement, or is it up to the practice?
Brian Law, for the record, I don't believe this requires the practice to have it. It gives them the ability to define it. I can speak from experience, however, is that they're going to define that. And I can use an example, for instance, when APRNs received independent practice, many of those facilities actually have policies that require them to be supervised. So I think it's the safe model, and they recognize that. I don't believe, as also speaking as a PA, I would want to enter into a situation where I did not have that collaboration and ability to be able to reach out and ensure that the patient care that I'm delivering has the best people involved. Does that answer your question?
Senator Stone, then Senator Buck.
Yeah, thank you. I just want to make sure we're clear on the semantics because I'm getting different vibes here. Will PAs be able to work independently without a collaborative agreement in any circumstance under this bill?
Brian Law, for the record, based on that section 4, it covers that a PA would not be able to work independently outside of those parameters. So within a facility, the term independent would be defined. I don't believe that they would be independent because they're employed at those facilities and have the oversight built in at that facility.
Okay, so you don't foresee any scenario, any environment, either in conformance with Section 4 or outside of Section 4, that would allow a PA under any circumstances to work without a collaborative agreement with a physician?
Correct, I do not.
Thank you.
Senator Buck, then Senator Scheibel.
Thank you, Chair Spearman. Sorry, I'm a little bit naive to this space, but what is the difference between a PA and a physician? Because it seems like you have an extensive background, and I just don't understand why you're not a physician then.
Brian Loft for the record. I also, hopefully Dr. Baker can weigh in because I can speak to what a PA is and I can give you some insight in terms of the comparisons. We're not physicians. We don't go to medical school. We don't go to residency. We're trained in the same medical model. And essentially how I like to describe it is that we compress medical education to a shorter period of time. The profession was developed out of fast-tracking physicians during the World War II, and they recognize that they can give them compressed information, send them to the battlefield, and then they learn the rest of it kind of in the moment. So the PA profession was developed after that model, and so what the model is that it gives us that foundational education, and then that's why the provision about the 6,000 hours after graduation to allow them to mature in that educational, in the environment which they will be working in.
And do you have separate liability insurance then that is for just you?
Brian Love for the record, yes. So I have my own individual malpractice policy named to me.
I just wanted to follow up on Senator Pizzino's question about the collaborative agreement and why not require a collaborative agreement? I understand that the purpose of the bill is to allow at the practice level for that collaboration to be defined by the parties involved, but why not require that once they do that and establish how many hours the PA will sit with the physician or talk to the physician and they establish who's in charge of what, why not just require them to shoot a copy of it over to the licensing board?
Brian Love for the record. I think the issue comes is the parity with our colleagues, the APRNs. They are not required to do that. Therefore, facilities with that added administrative burden will likely choose the path of less resistance in terms of hiring someone else who doesn't require that through the state board. So if your question is requiring it at the state board versus at the practice level, I think requiring it at the practice level is what we're trying to do. And I don't know if that's in statute or if that's the language that could be included.
I'm sorry, maybe I missed a very big point here, but I thought that APRNs could practice independently.
Brian Law for the record, absolutely. That is what I'm saying, is that they can practice independently. However, facilities reserve the right to be able to say, as an employed APRN, you're going to have a supervising physician assigned to you.
Got it.
If I may, Madam Chair. So for me, David Baker, for the record. So at Carson Tahoe Health, so we employ both nurse practitioners and PAs. And nurse practitioners after 2 hours can legally practice independently. We keep them under a collaborative arrangement. So again, I work closely with a nurse practitioner in my general clinic. She works at the highest level of her licensure, and we work together to take care of a lot of patients. I don't have any real true administrative burden to have her on board. Okay. I also have 6 physician's assistants that I have under agreements with. Carmela's being one of them. The issue there is she doesn't need my supervision, really. She doesn't need me to be filling out forms and that kind of stuff. But I have to by law. So now 6 people are under my licensure. I cover neuro, I cover pulmonary, I cover cardiology, I cover urgency care. It creates a big burden on the system and on myself to be able to supervise those people when I don't really need to. So we have systems in place at Carson Tahoe Health, and I think that's universal for any place, any large groups that employ PAs, where they are working collaboratively with the physicians around them to make sure that the care is good, to make sure that the cases that are difficult get discussed amongst a variety of people. But there is no administrative burden that, that the rest of us have to absorb.
So I guess my question is, relates to the military and the VA. I was just looking up here to see how many PAs were killed in combat, and there were several. What I know about being stationed with combat units is that they're typically assigned to a MASH, Mobile Army Hospital, and sometimes the physician is not there. What I also know is that there are times, even in cantonment, when we're not in combat zone, that the shortage of doctors sometimes requires that when I was stationed at Fort Hood, there was like one doctor that was responsible for like 3 of the clinics, and PAs work there. What has been the experience of the military? What has been the experience of the VA? Because every time I go to the VA, I see a PA. As a matter of fact, yesterday here I went to one of the urgent clinics. I was having some problems with allergies, and it was a PA that assisted me. So what does that look like? I'm trying to get a handle on it, because when people leave the military, they usually continue that practice in civilian life. And I know that in the Army Reserves, there are several PAs, and Army Reserves means you're not full-time active duty, but you're deployed whenever someone calls you or whatever. So what does that look like? What does that transition period look like between a PA and their duties in the military and a PA and their duties as a civilian healthcare professional?
Ryan Law, for the record. Thank you for your service first. And as a veteran myself, when it comes to taking care of patients, nothing changes, right? We're still held as PAs in the military and outside the military to adhere to the standard of care that's applied to physicians, PAs, and anyone who's providing medical care. The difference is that oversight and that collaboration. So in the military, PAs function very autonomously, independently, and within the teams that they're assigned to, just like the physicians do in the military. When that PA transitions to the civilian world, then depending on where they're at, if they're lucky to be in a state that does not have supervisory agreement, it's going to be more akin to their previous experience. If they happen to come to Nevada, they're going to be held to a higher level of administrative burden. Again, not changing their medical practice, but that administrative piece of it, and perhaps not be able or less desirable to come to Nevada to practice compared to another state. Does that answer your question, ma'am?
I think so. And maybe you can't answer this. You probably need to find out from research or something. But so what has been the experience of the healthcare field with the transition of PAs from the military and into civilian world? Has there been any degradation of services? Has there been any degradation of patient care? And I just want to point this out because I also saw this in, and anyone who's been in the military knows what these terms mean, but PAs serve in the military in various ranks, and they also serve as company commanders on brigade staff, and also serve as primary officers in a combat zone. Please tell me what that looks like. Here's the military, here's the VA, here's civilian. Tell me what that looks like, please.
So Dave Baker, for the record. People to come to us with that kind of service background are almost guaranteed to be very good under stress, which is an important thing when it comes to providing medical care. Tend to be very good leaders. Okay, they have some leadership history behind them, which makes them very valuable in the medical care setting as well. And they tend to be very diversely trained. So in the military, they may have a wider spectrum of people that they have to take care of. So they're more versed in, say, trauma or behavioral health issues with PTSD and those kinds of things. There's very diversely trained. So I think they fit well into a private model very, very well.
Let me go back to degradation of services and degradation to patient care.
Dave Baker again. Zero degradation. I don't see any. So as I understand the question, if they come from the armed forces and come into our private system, is there somehow a lesser level of care from those PAs compared to ones that maybe have more of a private?
Well, I guess specifically I'm asking, so in the military, direct supervision doesn't mean I'm standing right over you. Direct supervision might mean that the supervising doctor is at the main hospital, post hospital in Fort Bragg, or and the PAs are scattered around various clinics at Fort Bragg. So supervision in the military, as I'm understanding, is different than it is in some states. In some states, they have the same model as they do in the military. What we're talking about here is direct supervision that doesn't require direct presence, if I'm understanding that correctly. So someone who is stationed at Fort Bragg with the 82nd Airborne Unit, and they leave Fort Bragg and they move to any place that has a similar model. Has there been any degradation of services because the physician was not at the same facility but was in close proximity? As a matter of fact, I read somewhere some states require not direct supervision at the same site, but they have to be in close proximity and always in constant electronic communications. So I'm trying to understand this from a healthcare standpoint, okay?
Again, David Baker. So it's very similar to the model that we have. So like currently I'm officially on call at the hospital right now. I have two APCs over there that are seeing patients and getting things done. I'm their collaborative physician as we speak, and I've had a few texts that have come through, but no, they are autonomously practicing right now under my supervision. When I leave here, I'll go back and we'll talk through the cases and get things done. So I think what you're describing is almost identical to what we do, at least at Carson Tahoe, and I think in most healthcare professions, where the APCs, the PAs, are functioning autonomously in a setting where they have a collaborative physician either close by, somewhere close to a text, or one of my partners or something is there to help them should there be any big issues. But they are still practicing. There's a difference between independence, where you can just go out and hang your own shingle and just do what you want to do and there's nobody looking over you, versus sort of autonomous, where a PA can practice at the highest level of their licensure in a setting that is also somewhat protected by having physicians there for questions or concerns. I really don't see a difference between what you're describing in the military and what we do at Carson Tahoe.
If I may, I think, and you two are the experts in, John Sandy, for the record. I think what Mr. Loff was saying about the difference between the military is the military operates under a system which we're trying to work towards. And if I'm mistaken, the law, the big difference between the way it is today and what we hope it would be several months from now is that the doctors won't have to fill out the paperwork and submit it to the Board of Health to meet the minimum requirements that the board sets. Those requirements will be conducted by Carson Tahoe. So Carson Tahoe would say, doctor, you are to collaborate with these numbers of physicians, assistants, and to do so, the scope will be that we expect you to meet with them for 6 hours a month, and you will report to us, and rather than reporting to the board. That's the current way the VA is set up right now. And so we think that helps care because it frees up doctors so they're not filling out unnecessary paperwork to submit to the board, that they are able to use that time to work with the PAs and see patients. Is that fairly accurate, Doctor?
David Baker for the record. Absolutely. Yeah, I mean, it's a lot of the supervision, you put it on a form and I'm supposed to do this and I'm supposed to do that, but a lot of times it's basically it's a half-hour conversation in the hallway about a patient that's difficult. It's sharing charts. It's a lot of indirect supervision that we provide that still makes sure that the care is very high quality and safe for patients. The administrative burden of having PAs right now is real. Carmela mentioned the one time where we passed over a probably better qualified PA for a nurse practitioner, also well qualified, but did so because of the administrative burden was real. I just assumed the CMO job about 6 months ago. The prior CMO to me had, I want to say 4 PAs.
CMO?
Chief Medical Officer, sorry. He had 4 PAs under his supervision with the state. When he left, those PAs did not officially have supervision within our institution, and their ability to practice, to do their job and practice medicine was essentially gone until we can get somebody else to come up and fill that spot, which turned out to be me. I don't have to do that with a nurse practitioner. In the functioning world of our group, and I think most groups, we don't differentiate between nurse practitioners and PAs, but the administrative burden that comes on with the PA is real.
And this will be my last question. So where the current VA hospital is, I think there is a prominent hospital in Reno that has now in its name, is about 3.5 miles away, maybe 4 miles away. A PA practices at the VA and then applies to this hospital, and they leave the VA and they go to this hospital. What is the difference in their service, in the way they provide service in the VA, and then what they will be doing at this hospital? Currently, you can't do what the VA allows PAs to do. When I say that, I mean in terms of supervision, the supervision aspect, because I think what you're asking is autonomy, but not total independence. So what is the difference? I need to understand this for my own health, mental health. What is the difference? You have a PA that has served, because the medical system, wherever there's a VA hospital and wherever there's veterans, then those overlap, because there are times when veterans are sent to what they call community care because there aren't enough people at the VA to service that. And so if there's a shortage of PAs at the VA and they send them to community care, what is the difference in terms of their ability to do that versus what they already do at the VA? You understand what I'm saying?
Dave Baker again. I don't think there is a difference. So again, I have 6 PAs under my under the state. I supervise them in writing. I will have a clinic in Mammoth, California, a 3-hour drive from here. Those PAs don't stop taking care of patients when I'm gone, right? They still take care of patients, and I'm there to be as needed for any questions that come up. And also so the beauty of the collaborative system is, so like I mentioned that right now 2 APCs are running the hospital for me at Carson Tahoe. Well, one of my partners is also there. So if there are issues that come up from the PAs, I have a partner that's right there. I have 7 of them that are right there that can answer questions that come up for the nurse practitioners and PAs. So I think as far as your question is concerned, when somebody transitions from that care model at the VA into the private sector, there really is no difference. There is no supervision that mandates that I have to sit there the whole time with a PA or a nurse practitioner, because otherwise they'd be of no use, right? If I have to be there anyway, they'd be of no use. So I don't think there is a significant difference between the 2 worlds.
If I may, John Sandy for the record. So to answer your question specifically, so the difference is that the doctor that's working at the VA does not have to fill out the paperwork and send it to the Board of Medicine. The doctor at Renown will have to, once a month, have to work and fill out the paperwork and submit that to the Board of Medicine. So if you're doing it once, that might not be a huge administrative burden, but as the doctor has said, if you're overseeing 8 PAs, that's going to take you several hours out of your month to fill out that paperwork, whereas that VA doctor won't have that same time crunch, that he will be able to spend that time, he or she will be able to spend that time working with PAs, collaborating with his other partners. It's the administration of what we are trying to lessen the administrative burden through this bill.
Madam Chair, Brian Loft for the record. If I may, a PA in the VA system is a federal employee. They're actually not subject to state licensure. So that PA could be functioning in the VA providing the care and choose to do that to avoid that state requirement in their licensure and that burden. If they wanted to go from the VA to the community, they would have to go through that process. So in fact, it would actually prevent a PA in the VA system to actually, not prevent, it would hinder a PA in that system to go out and do the same care. So the medicine wouldn't change, but the ability to do it would be hindered.
Thank you. Additional questions, committee? Okay, you have any other presenters? Okay. If you step back, we'll now open up public testimony for those in support of Assembly Bill 364. Either here or in Las Vegas.
Thank you, Madam Chair, members of the committee. Blaine Osborne, Nevada Rural Hospital Partners. Happy to be here in support of AB 364. PAs are critical to the access to care in rural Nevada, particularly in our rural health clinics. We think this bill does a very good job in balancing the reduction of administrative burden with patient safety and quality. Thank you.
Good morning. My name is Ann Hines Miles, M-I-L-E-S. I've been a PA for 20 years, and I've been living the dream. I've had the opportunity to work rurally and then finally in the frontier in Nevada, but it hasn't been easy. Working in the rurals, or especially in the frontier, it's not for a new graduate. You have to be an experienced PA to be out there. You have to be trained in multiple disciplines, because you have to be ready for anything that comes through the door. Even if you're just there for family practice, you better be ready for an emergency. And that's why, as a healthcare provider, just like all healthcare providers, we develop a team of professionals that we can call on: doctors, PAs, nurse practitioners, pharmacists, radiologists, EMTs, and I developed that. And I called on them when I needed to. The difference between rural and frontier: rural is most of Nevada. It's the small towns. They have pharmacies, grocery stores, paved roads, restaurants, places to stay, to where in the frontier you don't have that. The roads might not be paved. You just don't have any of that. And so my supervising physician was 86 years old. He drove 250 miles. Oops, I'm about out of time. But 250 miles to supervise me once a month, look at my files that I would pull out for him. And he was one of the few doctors that actually went through and looked at them and signed them off for me. And we'd talk for a couple of hours, but mostly it was about politics. And so I'm done. I thank you.
Thank you, Madam Chair, and members of the committee, and thank you for your service, Chairman Spearman. My name is John Larson. I'm a physician assistant practicing at Carson Tahoe Health. I work under supervising physician David Baker, who you've heard from today, and I'm grateful for the opportunity to be able to do it. Prior to graduating physician assistant school at Eastern Virginia Medical School, I was a respiratory therapist for 6 years. And the great thing about being a PA is it allows me to use that, all of the training that I've had in my life to help those patients that I see. So I work with chronic lung disease patients, and similar to Carmela Downing, we try to reduce readmission to the hospital. It's important to know that my training as a physician assistant is all about collaboration. I mean, that's how the profession came about. So all of my training, from a respiratory therapist up to PA school, was about working as a team in healthcare. I'm happy to work with nurse practitioners. I'm happy to work with physicians. The reality is that PAs and nurse practitioners are considered equal in healthcare, but PAs and nurse practitioners aren't legislated equally. And so I am in full support of AB 364, just in the interest of equalizing my experience with the experience of my peers that are considered equal to me. And I appreciate your time. Thank you.
My name is George Ross, testifying on behalf of Touro University. We support this bill on behalf of our physician assistant program. Thank you.
You're former Navy, correct?
Yes, Navy.
Thank you, Chair Spearman and members of the committee. For the record, my name is Austin Brown, B-R-O-W-N, and I'm here on behalf of the University of Nevada, Reno to provide support on behalf of AB 364. In keeping my remarks short, I will just say that this bill will increase our state's capacity to address the public health and growing healthcare shortages throughout our state. Thank you for your time.
Additional persons? I see someone in Las Vegas, so let's go down south and support.
Good morning. My name is David Brems. I am the Operations Director for Intermountain Health, supporting telehealth services in the Nevada area. I also have a doctorate degree in the nursing practice. Intermountain Health entered Nevada in 2019 with the intent to improve access to quality healthcare in the community. We currently have 65 clinics and 2,000 caregivers serving approximately 400,000 patients in Nevada. Intermountain Health is a complete health system with operations in 7 states, including 33 hospitals, 385 clinics, and over 3,800 employed providers. We are committed to providing the high-quality care Nevadans deserve. As an operations director, I am working to improve access to care for my friends and neighbors who live in communities large and small throughout Nevada. Currently, there aren't enough specialty-trained providers to supply the specialty care Nevadans need, particularly as we get into more rural communities. We have learned that we can increase access by providing care via telehealth, but even with that, access to specialty-trained physicians is limited. It is not uncommon for a patient to need to wait months to get in to see a specialty provider. Let me share a personal example. When I moved to Las Vegas, I needed to find new doctors for my family. One doctor we needed was an endocrine specialist. It took me 3 months to get into a primary care provider, and the specialist was 6 months out for an appointment. I begged and pleaded with the specialty clinic to see me sooner. During my wait, I had to visit my previous endocrine specialist who was out of state for a prescription refill. I finally was able to convince one of the specialists to see me virtually when a cancellation came up on their schedule. If I wasn't on the inside track, working in the healthcare field and knowing how to navigate the complex healthcare system, this would not have happened. Healthcare access is an issue for all Nevadans. Passing AB 364 will increase access to primary care and specialty care for all citizens of Nevada. Enabling advanced practice providers to operate at their full licensure will decrease wait times, improve access, and improve health care. I hope you will choose to vote in favor of AB 364. Thank you.
Anyone else in Las Vegas? Support? Anyone else in Carson City? BPS, is anyone on the phones?
If you would like to testify in support of AB 364, please press star 9 now to take your place in the queue.
Good morning. My name is Daniel Villalobos. V as in Victor, I-L-L-A-L-O, B as in boy, O-S as in Sam. I apologize I can't be there in person, but wanted to introduce myself. I am a rural PA in primary care for almost 6 years. I'm about an hour and a half from Reno. I was born and raised in Smith Valley, Nevada, which is a very rural community with limited access to healthcare. And growing up there, I witnessed firsthand the limited access to healthcare, which is why I chose to come back home to provide care to the community where I was raised. When I began my career, I actually worked with current Senator Dr. Robin Titus, as she was an assemblywoman at the time, which also required her to be in session for 6 months duration. Thankfully, she wanted to keep our clinic open, so she agreed to sign my charts and be my supervising MD during those 6 months while she was in session. If she didn't agree to supervise me, the community would have suffered as we would have had to close the clinic. More recently, as we all know, Nevada's population growth is far outpacing our healthcare ability. And my current supervising MD and I are very busy, and if for any reason he decided to relocate or do something else, we would have to close our current clinic, and I would have to uproot my family and move. And of course, the rural community would not get the care they need. Our surrounding states are already ahead of this concept, and so I think with our population growth and our future in mind, we're going to have further healthcare strains. It's hard enough to get rural providers as it is, but it's only going to get worse with our growing population. I strongly support AB 364 and hope you all do too. so we can make sure our future rural Nevada residents have access to health care. Thank you for your time.
Caller Kurt Bramble, you can begin.
Thank you. Can you hear me?
We can hear you.
Great. Madam Chair, members of the committee, my name is Kurt Bramble, State Senator in Utah. I had the privilege of passing the PA bill here in Utah 2 years ago. And a couple of points that I think need to be emphasized. When you talk about collaboration, the reality is in the medical fields, collaboration happens as a regular occurrence. For example, if you have a family doctor that has a patient that has various forms of cancer, they're going to refer that. They know what the limit of their skills are, and they're going to be referring. Well, the same thing happens with PAs. Here in Utah, we had a situation in Gunnison. It's one of our rural communities that there was a PA, a physician and a PA. They were the sole providers in Gunnison. Dr. Inouye passed away. They'd been practicing together for 13 years. In the ensuing 2.5 years, because of COVID, there was no way to get a supervising physician in place in Gunnison. This came out in committee that the Utah Medical Association recognized that the quality of care, the patient outcomes from the PA were just as good after the death of Dr. Inouye as they were when they were working as a team. So the issue of supervision, the issue of collaboration, it's been well covered. I think the one thing that we found here in Utah, access to healthcare, particularly in a state that has a significant amount of rural communities, fairly sparsely populated, having physician assistants that are able to provide those services became critical. So we not only passed a bill here in Utah, Senate Bill 27 and Senate Bill 28 in the 2021 legislative session, that one was on healthcare, general healthcare. The other one was mental health, because in both areas, we have a significant lack of access to competent care. The PAs are going to practice to the top of their training, their experience, and their education. But there are other external forces. For example, insurance companies, privileges, the tort liability system for malpractice. All those act as checks and balances on PAs at whatever level they're practicing. So I would encourage you to give this bill careful consideration. Here in Utah, we've actually opened up our licensing that any licensed professional, PAs, doctors, if they're licensed in another state and their license is current, all they need to do is come to Utah and we will grant them a license. We'll endorse their license unless there's some compelling reason to believe they're not qualified. That's the direction that this country is going in providing access to healthcare, and I'd encourage you to pass this bill. Thank you.
Thank you, but that wasn't a recruitment statement, right?
That was recruiting. No, look, we come to Reno with our hot air balloons regularly. The Great Reno Balloon Race. I have several close friends in the Nevada Legislature. No, it wasn't that. I was just trying to point out that Nevada, you don't want to be behind the eight ball in terms of being able to have a robust medical healthcare community, including PAs, nurse practitioners, physicians, and specialists.
Okay. Thank you. Anyone else? Anyone else? So we'll move now to those in opposition of Assembly Bill 364 here in Carson City, and don't see anyone in Vegas. Let's begin when you're ready.
Thank you, Madam Chair. For the record, Susan Fisher with McDonald Carano speaking today on behalf of Nevada State Board of Osteopathic Medicine. We are opposed to the bill as presented to you today, AB 364. I have not heard anything here today that would help get more physician assistants practicing in Nevada, that would get more physician assistants practicing in our rural areas or critical access hospitals. There's nothing that says they're going to get more here. Now, expanding PA programs so that they have a greater teacher to student ratio so that they can be cranking out more of them, that's terrific. But to say that they won't go to rural areas because there's not a physician there to supervise them. And as the senator from Utah said, he mentioned that they couldn't find a physician to go into the particular town where the physician had died, so the PA was unsupervised. We don't have that problem here because under NRS 633, no, that's the wrong one. Under NRS 633-469, Section 2, that's in the osteopathic statute, it allows a physician assistant to be supervised by a physician who is in a different geographical location. And I will read that to you into the record. Except as otherwise provided in subsection 3, a supervising osteopathic physician may provide supervision to his or her physician assistant in person, electronically, telephonically, or by fiber optics. When providing supervision electronically, telephonically, or by fiber optics, a supervising osteopathic physician may be at a different site than the physician assistant, including a site located inside or located within or outside this state or the United States. So they don't have to be on site. You could have, it appears that what they're trying to do is reduce an administrative burden. What I would also point out, I know that Dr. Baker mentioned that he supervises, I think he said 6 PAs. Now in osteopathic, NRS 633-288, they're allowed to supervise 3 to 1. And I believe that, that the Board of Medical Examiners has the same ratio, 3 to 1. Expand the ratio would be a good recommendation. You know, I don't mean to be glib here, but I've worked in a law firm now for over 9 years, and that equates to over 700,000 hours. Should I be able to practice as an attorney because I work in a law firm? If the physician assistants want to practice as a physician, then finish law school. Or, I'm sorry, finish medical school. They are very highly trained professionals. We need them, just as we need the APRNs. We need all these mid-level providers, but they do need the supervision. Thank you.
So, thank you. So, here's a question. You said you haven't heard anything. What would constitute expansion?
Well, for instance, you heard a bill on the nursing school. There's a ratio of instructor to students that we have. It's 8 to 1. And we heard a great bill this morning about expanding that ratio so that the one instructor can teach more nurses. That way you can get more into the teaching programs and get them out, get the nurses out in the field. Expand the PA programs in the PA schools so that they can teach more. Have the somebody mentioned that at a PA school here in Nevada, theirs they had 24 openings. They had over 1,000 applicants, but they only had 24 openings. We need to help expand those programs to get more of these trained professionals in the field.
So one last question, it's probably rhetorical. So this bill, is your understanding, and now I'm unclear, is your understanding that this bill would allow PAs to practice as doctors?
Susan Fisher, for the record, if they're practicing autonomously, they're seeing patients, they're billing, they're not supervised, they are practicing in the same way that a physician would be practicing. And they're doing a lot of the same things that physicians do, which is fine because they are highly trained, but they are not physicians. And I think there's some confusion for the patients as well. If a PA comes in and that says Dr. So-and-so on their badge, they think that they have an MD or a DO.
Okay. I'll ask for clarity of the sponsors when they come back, because, thank you.
Thank you, Madam Chair. For the record, Andrew Pasternak, ANDREW-PASTERNAK. I'm a family physician in Reno, Nevada, and I'm representing the Nevada State Medical Association testifying in opposition to AB 364. We heard in the opening comments that nurse practitioners aren't opening their own independent clinics. I can give you plenty of examples of where that is happening, including a nurse practitioner who quit working in my office, where I take Medicare and Medicaid, to open her own concierge practice, where she's only helping those who have the financial means to pay her. This bill would allow PAs to follow that same pathway. I was recently talking to my best friend from med school. He has 2 kids. His son graduated college 2 years ago, and his daughter graduates college this weekend. Both are interested in medicine. His son has decided to become a PA, and his daughter wants to become a physician. She starts med school this fall. You've heard about the training that my friend's son is going to go through as a PA, but the key is PA schooling focuses on how to be a PA and work in a healthcare team, not how to be an independent clinician. His daughter's med school is going to be 4 years and 3 challenging step exams, then residencies with long hours into both inpatient and outpatient settings for anywhere from at least 3 to 5 years and often more. So it's often 7 years before she can practice independently. My friend has had very frank discussions with his kids about their career paths. While they both want to enter medicine, they're picking different training paths because they want different roles within the healthcare team. Physician's assistants are a critical part of our healthcare team, but PA training focuses on how they can work under the supervision of a physician as part of the healthcare team and not as an independent clinician. We're hearing a lot today that there are burdens to supervision, and I think we all agree with that. So let's look at ways to streamline that supervision process instead. There are plenty of opportunities for physician's assistants to practice as part of the healthcare team in underserved areas in Nevada. Passing AB 364 will do little to help this void. Thank you.
Thank you, Madam Chair and members of the committee. My name is Erin Simmers. I'm an emergency physician practicing in Reno, Nevada. I'm representing Northern Nevada Emergency Physicians, which is a Democratic group here in Reno. I've also been the education liaison for the group. We work with a PA training program, and I've worked with them extensively. I'm not military, but there's a saying that we borrow in emergency medicine that's attributed to Navy SEALs, which is that under pressure, we do not rise to the occasion, we sink to the level of our training. The requirements for a PA training program state only that supervised clinical practice must occur in the emergency department. There is no hour requirement, there's no shift requirement. At our affiliated PA program, these students could meet this requirement with 14 shifts. That level of training is 2 weeks. On-the-job experience just can't compensate for that, and we've seen that with nurse practitioners. There's a study out of the VA that shows worse outcomes from nurse practitioners practicing independently in the emergency department. And these are experienced nurse practitioners. If you read my written comments, you can see a case that I just took recently from a rural hospital that was a very experienced PA who had to stabilize a patient, transfer them to our facility, but she couldn't do it. She didn't have the training. Her note said, "I did not feel comfortable doing this myself. I instructed the patient to find her supervising physician." She says Dr. X was available and did come down. He completed the procedure, and we stabilized the patient and transferred them here to Reno. This particular PA had finished her training in the late 2000s, but when she sunk to the level of her training, she couldn't do it. In a life or death situation, our friends and family deserve the safest care, and the optimal team in the emergency department requires a physician. We can't take this safety net away. Thank you.
Good morning, Madam Chair, members of the committee. My name is Sarah Watkins on behalf of the Nevada State Medical Association, here in opposition to AB 364. As a patient and physician advocacy association, members of our association truly understand the important role that the physician assistant plays in the healthcare team. However, expanding this mid-level position would cause a split in the healthcare system. The comparison in education and training between a physician assistant and physician are not equal. Medical school expects a much deeper and extensive understanding of advanced sciences at a prerequisite to entry. This foundation is then built upon extensively equipped physicians with the skills, knowledge, and understanding to provide care that can range from simple to very complex. The physician assistant, as the name implies, has a very different expectation. The curriculum is founded on the principles of assisting a physician, and it uses a curriculum of 2 to 2.5 years compared to a physician's curriculum of 4 years and then 3 to 5 plus with residency training. The The broad brush expansion found in AB 364 is a dangerous precedent to set in Nevada, apart from almost every other state in this nation. This 200-page bill would be a wide-ranging scope expansion without consideration of patient safety. For example, this bill includes language that specifically allows physician assistants to determine whether an infant has critical congenital heart disease after being flagged on a common infant screening test. Currently, only physicians can confirm this diagnosis. If this diagnosis would be incorrectly diagnosed and treated, it could then lead to severe complications and possible death. Additional studies have also found that mid-level providers tend to prescribe more frequently compared to physicians. So for an example, a 2020 study published in the Journal of Internal Medicine found that almost 8.5% of physician assistants prescribed opioids to more than 50% of their patients. This is compared to 1.3% of physicians that do this prescribing. The study further found that in states that allow independent prescribing, physician assistants and nurse practitioners were 20 times more likely to overprescribe opioids than those in prescription-restricted states. There is a letter that was submitted by the AMA that has more details that was sent to the committee on this. A team structure and access to high-quality care should be the goal for citizens in the state of Nevada. Allowing more independent practice of mid-level providers will cause a divide in this healthcare system, and it is not the solution. I do thank you for your time.
Madam Chair and members of the committee, again, my name is Dr. Brett Fry for the record, and I am representing today the American College of Emergency Physicians Nevada chapter, not the Board of Medical Examiners. Just wanted to point that out. Thank you. Words matter, and words in this bill particularly matter with respect to ensuring public safety. Senator Stone pointed out and asked the question if there's any circumstance where a PA would practice independently, and the answer was no. But then it was further clarified that a facility could allow independent practice, which would effectively remove the current statutory requirement by leaving it to the facilities. Please allow me to point out a section in the bill. It's section 4, paragraph 1A, and I'll give folks a moment. But just after the important word "or," it says, any facility that has established a system for evaluating the credentials of and granting practice privileges to physician assistants. I would point out that this language leaves an opening for those practicing outside of a hospital system or a credentialed clinic that is owned by a system or physicians to essentially open a medi-spa and do cosmetic procedures ad nauseum. We see this a lot, and it is a constant problem for the state. People get over their skis, they practice outside of their scope, and complications occur. So that language is particularly problematic because it doesn't spell out facility as defined by NRS. This bill would allow, as written and amended, a PA-owned facility to spring up, if it's outside the scope of a hospital system or, again, a physician-owned practice. And they would essentially write their own credentials. Again, 6,000 hours, it's been brought up, is sorely inadequate. In order to practice lawfully in the state of Nevada, I needed to do 16,000 hours of supervised training in order to hang my shingle in an emergency department. The fact is that I saw the sickest of the sickest during that training. I didn't see the less complex people, I saw the most complex people. And we can't expect that physicians are going to suddenly create a new system of education during that 6,000 hours of work hours to ensure that physician assistants are seeing the most complex patients so that they are prepared for independent practice. And it will be independent practice if a facility says it's independent, because we're essentially giving this from the board over to facilities with this legislation. So in closing, I think we should not assume that PAs will be fully prepared for independent practice because 6,000 hours of time has passed. We can assume that physicians will assign more complex patients to PAs along the way. and we can't assume this bill won't compromise quality and safety. I think we should listen to the patients who say they want the most experienced caregiver when their life hangs in the balance. Thank you. Take any questions.
Thank you. Anyone else here in Carson City? I don't see anyone moving in Las Vegas. BPS, anyone on the phones in opposition?
If you would like to testify in opposition to AB 364, please press star 9 now to take your place in the queue or raise your hand in the Zoom window.
Hi, my name is Layla Berg. I'm a PA. I work as a primary care PA for 8 years, but for the last year I've been working in urgent care in Las Vegas, where I identify myself to every patient and wear a badge that states clearly that I'm a PA, as is my legal requirement. Before I started at my current position, I was offered a position working in a rural medicine primary care clinic. However, they were ultimately unable to hire me because they could not find a physician to take on the supervisory role. The exact same thing then happened again in an underserved community clinic. I speak Spanish, and I could have really helped these communities. Nevada currently ranks as the 49th state in the country for the number of primary care physicians per capita, and this is dangerous to public health. And I see this every single day in the urgent care facility that I work. Patients tell me that the wait for primary care is 4 months. A 4-month waiting list is unacceptable and dangerous, and the opposition to this bill isn't making any recommendations on how to remedy this crazy long wait time. Many of my urgent care patients come for conditions that should have been easily treated and prevented in a primary care setting, but instead they need to wait until the condition became urgent, which overburdens our urgent care and ER facilities and truly harms patients' lives. Additionally, the patients I see who are being seen by primary care are so undertreated because of the 4-month wait that I frequently need to add and adjust their meds, even though they're only there for acute reasons. Their primary zips in and out, and they have no time to fully address the patient's conditions because primaries are so flooded right now here in Nevada. In my urgent care, NPs who have no regulatory burdens consult with collaborators in other states who are hired by my company to do nothing but take their calls. NPs love having this access. PAs, though, have to have supervisors that are working in their facility, which severely limits the number of PAs hireable at my company. We are losing PAs to other states. Several of my patients were graduating PAs who told me they had better opportunities in other states, which have already passed legislation similar to AB 364. I strongly support AB 364. Thank you for listening.
Thank you. And ma'am, can you spell your name? And I think you said you are in support. I think that's support. Okay.
Leila, and my last name is Berg, and I'm in Las Vegas, and I'm in strong support of AB 364. Thank you for listening.
Thank you. BPS, anyone else?
One moment, Chair.
Chair and Member Committee, my name's Stan Assistance. I had my hand up in favor and never got called on, and I'm being called on now when you're having testimony in opposition. Would you like to hear from me?
Yes, please.
Senator Bramble was good enough to come and give you some feedback from his perspective. He was the sponsor of a bill that I believe this bill is modeled after, although it's not quite as comprehensive as the Utah bill that passed was. There are 3 things that I think if I were the decision maker on this, I'd be thinking about. The first one is that this is modernization of the relationship between a physician's assistant and the rest of the healthcare system. For years, they have been in this under the supervision of, when in real practice, they are more of a collaborator. And as they get experience, they go from that under the supervision of to more of a collaborator in the process over a long period of time. So the language that talks about the collaboration of is more of a reflection of what is actually happening rather than some new construct on their scope of practice. The second thing I'd look at is access to health care. And in Utah, we have a problem in getting health care to underserved communities. And that can be rural Utah, it can be communities of color, it can be those in poverty, it can be the homeless population, but they have real challenges in getting access to health care. And physician assistants fill that gap. When physicians are unwilling or unable to deal with these underrepresented populations, it's physician assistants that come in and fill those gaps many times. And so this is an opportunity for more access for those communities as you allow physician assistants to again, become more of a collaborator in the healthcare process. And the third thing is cost. For 30 years, I saw the same physician, and for about 15 of those years, he had us seeing others who worked in his practice. And one day I was talking to my doctor, and he had been seeing me and my family for about 10 years at that point. And I said, "Hey, doc, what's going on here?" And he said to me, "Stan, I am a physician assistant, and you're not allowed to call me a doctor." And I was stunned because the treatment that I got from him, the attention, the knowledge, the diagnosis and prescribing was every bit as effective as what I had gotten from the doctor in whose practice he was functioning. And that's what kind of clued me into the fact that that physician assistants are every bit as capable in those family practices of being the first, of being the door into healthcare needs for families. So those are the three areas. It really is modernization to reflect what they're already doing. It is about access, and it is about cost. And I would encourage you to pass this bill.
Caller 166, could you state your name?
This is Nick Espiritos, MD. I'm the Vice President of the Board of Medical Examiners for the state of Nevada. Although I'm not speaking on behalf of the board, it should be noted that the legislative subcommittee voted unanimously to oppose this bill. This bill is problematic for the following reasons. In Section 12 and 28, they eliminate, and I quote, provisions governing the testing or examination of applicants for licensure as a physician assistant. It allows authorizing certain unlicensed persons to use the title inactive physician assistant. Regarding the prescribing of dangerous drugs, Section 36 removes a requirement that the board consider the experience and training of the physician assistant when adopting those regulations. And lastly, as stated previously, the site of practice limitation is nothing more than smoke and mirrors. as independent practice sites are only limited by the requirement that that facility, which is undefined, may establish for the credentialing of physician assistants. This is a complicated issue, and many specifics of this bill are being glossed over, and there are many ways to address the practice of PAs in Nevada beyond what is included in this bill. It is interesting to note that, unfortunately, as much as the word collaboration is used, there has been no request from the PAs to meet with our board to discuss how we could have collaborated on this bill. The access to medical care issue will not be resolved by lowering the qualifications of those providing that care, particularly without required collaboration. You should also note we have significant problems with physician oversight as it is, as PAs are being overseen by physicians such as ER physicians deciding to oversee PAs practicing cosmetic surgery. We have incredible problems in the state of Nevada with physician assistants practicing outside the specialty and being supervised by physicians outside of their specialty. It should also be noted that no states outside of an emergency setting have laws that provide physicians assistants to practice without at least a collaborative agreement. AB 364 does anything but protect patient safety. And as far as I can tell, it seems that we want to all the words of collaboration are used, then why not require collaboration? And the requirement of that would not in any way limit the practice of the physician assistant. I will end with one last thing. If you read that bill carefully and the lack of restriction in terms of prescribing dangerous drugs, this would essentially allow a PA to practice medical oncology, gynecologic oncology, because this removes the requirement that the board consider the experience and training of the physician assistant when adopting those regulations. I think this is abhorrent and really an unreasonable bill to even be considered. Thank you.
Can we get your name and spelling, please?
Nick, N-I-C-K, middle initial M, Spiritos, S like Sam, P-I-R-T-O-S.
Thank you.
Kim, you're unmuted.
Hello, my name is Kim McFarlane, K-I-M-M-C-F-A-R-L-A-N-E. I'm a physician assistant. Can you hear me okay?
Yes, we can hear you.
Yes. My daughter and her, thank you for your time to address you. My daughter and her family live in Alamo, Nevada, and receive their health care from PAs from Caliente. I am speaking pro to Senate Bill AB 364 because I was unable to speak during the pro testimony. I'm the immediate past president of the Utah Academy of Physician Assistants and was involved in passing the Utah's PA Practice Act. I've been practicing as a PA for 25 years. For 12 years as the sole medical provider in Frontier Community Health Centers, where we accepted all comers, including ambulances responding from medical and trauma emergencies on I-70 in Utah. I now practice with Intermountain Health in their telemedicine program, Connect Care Urgent Care. I am currently licensed in Utah and Idaho. For almost 2 years, I was able to practice and serve patients in Nevada through telemedicine during the COVID-19 public health emergency waiver. After the emergency waiver ended, our group of about 21 PAs were no longer able to serve patients in Nevada, while our 11 NPs have been able to continue to serve patients in Nevada. The current law prevents Nevada patients from accessing care by our group of PAs. The passage of AB 364 will allow Nevadans to access care provided by our group of PAs, especially during nights and weekends, since our practice is a 24/7 practice, 365 days a year. Our group has been able to save nearly $100,000 a year by removing requirements for supervising physicians in Utah and Idaho, where most of our licensed. This allows our group to hire more providers and to serve our patients. Removing the requirements for supervision for experienced PAs will allow us to also license PAs in Nevada to serve our constituents. Also respond with Utah DMAT 1 as part of the federal disaster response system. Under that system, as a federal employee, I do not have a supervising physician and deploy as part of a team who works together to serve in disaster response. There is no degradation of care when I am deployed or when I return home. I provide the same level of care. Like physicians, when PAs see patients who have problems beyond our expertise, we consult and refer to the appropriate person who can best evaluate and address those complex problems. Utah has seen no PAs in front of a licensing board for probation issues since our legislative change. There's high quality evidence that PAs provide excellent care, increase access to care, and work in rural and underserved areas at a rate higher than our physician colleagues. I ask you to support Senate Bill or AB 364 and remove the requirement for experienced PAs to have a supervising physician. Thank you.
Public line is open and working. There are no callers at this time.
Thank you, BP. Now we'll go to those in neutral. Anyone testifying neutral here in Carson City? Anyone in Las Vegas?
Hello, my name is Karen Massey. For the record, KarenMassey. And I'm the legislative liaison for the Medical Group Management Association in Nevada. So I just wanted to, I was not prepared to testify, but I heard a couple comments that I wanted to add to the record, if I may. Thank you for your service, Senator Spearman. My son also served at Fort Hood, so I've spent a little time in Killeen myself. There's no doubt for most of our membership medical groups around Nevada that PAs are a huge part of their practice. PAs working at the top of their license add a lot to our medical system and is a really important part. My concern about the particular bill that's in front of us is that the regulations serve to be the bare minimum. The folks you've heard from today are incredibly trained. The folks you've heard from medical practices, from Carson Tahoe, from my knowledge about our medical practices and how Renown uses APPs, they're very responsible in collaboration and supervision. And so I would just urge caution that what goes into law is the minimum for people who will be outside those systems. I think my personal observation is there could be a great deal of flexibility and collaboration that maybe would look like an amendment that would aid in reducing the bureaucracy of the requirements. To my knowledge, there is no paperwork that is submitted once a month. I think it's more flexible than that now, and it may be more flexible in the future. There are documentation requirements at the beginning of a relationship and documentation requirements at the end. There are collaboration, interaction requirements, but there's not a transmission of paper on a monthly basis, to the best of my knowledge. And I'll phone a friend if anyone has additional information on that. But again, I think the ratios that are set by the boards have become cumbersome for some of the larger practices. There might be some opportunity for a medical director, like you heard from today, to be able to supervise a broader group of individuals. But I think it's interesting to me to listen to all this testimony and hear everyone very positive about collaboration, but then the bill has elements that speak directly to supervision. So again, I would just caution that what I read in the regulation is the minimum standard, not so many of the responsible people you've heard from today. Thank you very much.
Thank you. Any questions? Okay. Anyone else here or in Las Vegas neutral? BPS, anyone on the phones?
If you would like to testify in neutral for AB 364, please press *9 now to take your place in the queue. The public line is open and working. There are no callers at this time.
Thank you. I know that Assemblywoman Cohen had to leave, but she pointed to somebody over here and said that they would do closing comments. And I do have a couple of questions, too.
Madam Chair, thank you again for the opportunity to be here. John Sandy for the record. You guys have been very gracious with your time, and I appreciate your attention on this matter. So I don't want to relitigate all the things that were said. I will just say I did pay attention when you cited my obligations as a lobbyist and to tell the truth and be factual, and I put on the record what our stated intent was. It was my observation that the opposition broadened what I believe this bill is trying to accomplish, and if the language needs to be wordsmithed, I'm more than happy to collaborate with them. We did reach out with to all the parties and most of the people that were in opposition. We have had conversations with it at various points during the session. But again, we are willing to work on language if in places it's overbroad or goes beyond what our stated intent is. So with that, I'm happy if there are some final questions, but did just want to thank you all for your time.
So one of the things that I guess is a little bit disturbing, and I'm trying to remember, because I think I asked the assistant director of the medical board about people who practice unsafely and how do you know? And I think PAs were in that bill, and so there are already consequences for people who practice outside the scope. Yes or no? Legal?
John Sandy for the record, absolutely. If you're a PA, you have a scope of practice, a scope of skill sets that you've developed, and if you practice outside of that, the board will absolutely discipline you for that.
And so the other thing that I'm unsure about, and that is, I think we've used supervision, autonomous, and indirect interchangeably, and I'm not sure that those three words mean the same thing. What is the bill trying to do in terms of, with respect to specificity and supervision? Autonomous, and what does that mean? Indirect, what does that mean?
For the record, John Sandy. You guys are hitting on the right questions. So autonomous, we're not seeking to be autonomous. I think that's the situation where you heard about the med spa or the pop-up PA clinics, as I've termed it. That is an autonomous practice. That's not what we're seeking, and we've already agreed to language in the assembly that we thought addressed that. If there's further clarification to prevent the med spa situation from occurring, again, that's not our intent to do. So autonomous, from my perspective, is over here. This is where we're focused on. Now, the supervision versus collaboration, I think, is a really good question, and one that I am even struggling with myself to understand the legal relevance to the two terms. I think in part it is to reflect the practice as it is today. It's not really a supervision. One of the ways I've thought, and I appreciate the doctor's thoughts on this, is it's like a football team, right? The way supervision is the doctor's the coach, and then the players are all the PAs and other providers. Whereas that's not really what's occurring. The physician's the quarterback, and everybody is working as a team to provide the best health care they can. And so I think using the word collaborative is in part, I don't know that there's a legal significance so much as there is a reflection of what is really truly occurring in our healthcare system. So that's how I would answer that question.
David Baker for the record. A couple of things came up listening to opposition. One is the level of education and training between the two specialties, and it is obviously real. I mean, it took me 15 years of education and training to get to where I could practice as a cardiologist, and we understand physician's assistants and nurse practitioners don't have that level of education and training, and that's why we keep them, work with them in a collaborative arrangement. Which is key, because when they're in a healthcare system and something bad happens to a patient, that patient's care does not fall to the lowest level of training for that individual. It rises to the highest level of training for the person in that team. So I think across the board, the other clinics that I've seen who have employed PAs have collaborative arrangements with physicians that are right there. If somebody crashes in Carmela's heart failure clinic, one of us is there, myself or one of my partners is literally right there to raise the care of that patient to the highest level of training in that team. There is no degradation of patient care because they're primarily being seen by a physician's assistant. We are there to back them up when needed on real time. That's the power of the system that we've put together. And it's not our system. If you go to any other large, significant group around the country, that is how PAs, NPs, doctors work together.
And so you're a real doctor, you just don't play one on TV.
Dave Baker again. I was in a few commercials for Carson Tahoe. That's as close as I've ever gotten to TV, and I don't want to get any closer than that.
Oh, again, and I'm just trying to, because you're a doctor, and we've had some doctors in opposition, but they're 180 degrees apart.
David Baker again. So the opposition, and I understand it, they're worried about PAs or NPs starting to work pretty much independently like a physician would. Okay, so I am fully licensed and credentialed. I can go start my own practice if I want to and be all by myself. I don't want to practice like that as a physician, okay? I may have had several cases this week where, it's like, well, this is a little bit weird. I pull in my other physician colleagues to discuss the cases. I routinely go to Carmela for advice on heart failure. She does a lot of it. We talk about a lot of patients. I routinely talk to my PA colleagues as colleagues directly. The team concept, the collaborative concept is powerful. And again, because we can take care of more patients than I could by myself in a way that when things get rough, we're there to make sure that the patients are cared for at the highest level of my licensure, my training.
And this is probably for, and I'm going to get you Senator Daley and then Senator Pizzina and then Senator Scott. So indulge me just a minute. So I need to be clear in my mind because some of the allegations of PAs going to practice on their own. If they do the things that were mentioned in the testimony as examples of them moving to practice on their own, and it's not in the scope of practice, would they be then subject to disciplinary action, and who would not know that?
For the record, John Sandy. If they practice outside the scope of their practice and what they're licensed for, they will absolutely be disciplined. As for who would alert the board of that, I mean, obviously any patient that had concerns could file a complaint with the board. But also, again, if you look at the sections and the areas that we've specifically enumerated where a PA can practice, and it's under section 4.1 A, B, C, D, E, and F. The first one, and to my knowledge, is a hospital. And if we need to work on the language to tighten that up to say that it can't be a med spa, totally open to that. The second, I believe, is a facility owned by a doctor. The doctor will be there or should be there and monitoring their practice. So that's a clinic that is owned by a physician. The second is a FQHC, which is a federal qualified health facility. Again, doctors are typically present at those locations. The other is a correctional facility. Quite often, there's a lot of healthcare that happens at correctional facilities. Physicians and PAs are both employed to do that. And so, again, there's that oversight. The last one was where we made the amendment, and that was section F, that said any other clinic that is approved by the board. There was concern that that's where the pop-up PA clinics would be because the board could theoretically license a clinic owned by a physician assistant. And so that's where we added the language in the amendment that's on Nellis that says, if you are practicing in one of these facilities, then you have to have a collaborative agreement. And so we hoped we covered all the bases to say, PAs are only going to be practicing where there's doctors and other healthcare providers. They're not going to be practicing in their own clinics. That's not our intent. That's not what we've been trying to do. I know there's been testimony saying that's not what the bill does, and if that's it, again, I welcome some feedback on how we can tighten that up. But we are talking about team practice and bringing that at the practice level. That's the scope of what our bill is trying to accomplish.
Okay, one last question, and I think it's Senator Stone and Senator Pizzina. Did I get that right? So one last question. So with respect to the pop-up clinics, if someone knew about that, would there be a duty to report?
For the record, John Sandy, I don't think our bill addresses that, but again, happy to consider that.
Well, is there someone here from Sarah, from the medical Board, if there's someone practicing outside their scope of practice, is there a duty to report? Let me get somebody from the Medical Examiners Board. Is there a duty to report? Because I just can't remember which bill it was, but I think we talked about that in one of the bills today. So if someone knows that there's someone acting out of the scope of their practice, is there a duty to report?
Thank you, Madam Chair. For the record, Tom Clark here on behalf of the Board of Medical Examiners. If another physician sees a physician practicing outside of their scope, are they required to report?
Anybody, because it appears that the physicians are at the top of the food chain. So if a physician knows that there's someone practicing outside their scope, if a PA knows that there's a PA practicing outside their scope or an APRN, anybody in the medical field, is there a duty to report?
For the record, Tom Clark, I believe there is. Is it in a regulation or a statute? It is not. I think you heard testimony earlier where the good doctors want to make sure that the bad doctors are gone. And I think that scenario is throughout the entire healthcare industry. So if a PA saw a physician not practicing well, they may not have a specific statutory duty to report, but I think they probably would report to the Board of Medical Examiners.
And so I think that goes to the question that I asked in one of the earlier bills. What is the duty to report and who reports that? And I think right now the medical board errs on the side of trying to make someone who is less than proficient, trying to get them to be proficient. So I'm going to ask ask LCB, can you look that up for me? Is there a duty to report? And if not, then I believe that should go in this bill, should go in several statutes, so that if you know someone who has a medical spa and it is outside the scope of practice, you ought to be reporting that. And if you know of someone who is a PA and practicing or putting themselves forward as a doctor, you have a duty to report that before you come to this committee. So, LCB? Yeah, just a minute. I need LCB to respond to that. Is that anywhere in statute, the duty to report?
I'm not aware of a duty to report. I know that the medical boards are authorized to receive those complaints from members of the public, from other practitioners, and that there may be incentives for practitioners or other people to provide those complaints. But I don't believe there's a requirement to provide that information to the medical boards.
Then I would say, Mr. Sandy, if you can alert the sponsor, based upon the testimony we've heard during this bill and also the one that Assemblywoman Peters brought, that there should be in statute a duty to report. If you walk by somebody's facility and you see that they are advertising and it's outside their scope of practice, you should report that. And I'll say this to everyone in the room, because we've heard that several times, that there may be a PA that would put themselves forward. If that is happening now, you should report that, because it is unsafe to the public. And the lack of safety that exists right now is not the same thing as justifying opposition to this bill, because there should already be a duty to report. And just let me be clear, if it's not in statute, I believe there's a moral obligation to report someone who is acting outside their scope of practice, because it endangers the population. And so that is what I would recommend to Assemblywoman Cohen, to put it there. And I'm glad to work with her on that, because I'm really disturbed by the testimonies that I've heard of people acting outside their scope of practice, but I didn't hear anything about reporting that. And so that concerns me. I think we have Senator Stone.
Thank you, Madam Chair, and I think you bring up some very good points, and I think probably the ones that are going to report it to the board the quickest are probably the competing physicians that are recognizing that a physician assistant has put up their own shingle and trying to provide services. So I think that kind of cures itself, at least from my standpoint. So Mr. Sandy, basically we talked about an hour and a half now. Basically the bill, I think, comes down to two things. One, you want to relieve the physician of these reporting requirements to the board in concurrence with the reporting requirements with a registered nurse practitioner, so that you don't have to have this burden of consultation, which really should be within the medical center environment, where change can actually happen. I'm not even sure if anybody at the medical board actually reads all these reports. They're probably submitted just because it's part of law. And number two, you want to add a physician assistant to the board, which I haven't seen any opposition to that. I think that's not an issue. So, but we keep hearing that people seem to feel that physician assistants, by virtue of this bill, are going to be able to be practicing autonomously, independently. So, and I've seen your amendment, but the amendment doesn't make it clear enough, I think, for me, and maybe my colleagues, and maybe people in the audience. And the amendment that you have submitted amends section 4 and 23 to state that the physician assistant must enter in a collaborative agreement with the physician if the physician assistant will work in a clinic that is not traditionally staffed or owned by a physician. I would prefer to see an amendment read something like this for your consideration. Amend section 4 and 23 to state that a physician assistant must, under all practice circumstances, shall not be permitted to practice without such a collaborative agreement. I think that would spell it out very clearly that they cannot open any kind of independent practice. And then maybe a second amendment eliminating the reporting requirements to the board as previously discussed. So I hope you'll take those into consideration. It would make me feel more comfortable with the bill. I think it makes it crystal clear that they are a team member, and I don't think we could work and deliver health care in this state without the wonderful physician assistants that we have from the top of Nevada to down in my district. And I just think you're looking for some regulatory relief, which I think is admirable and necessary. I'd rather see that time be put into educating PAs on how to maybe do their job better with their physician mentors. And so I hope that you'll consider that amendment. I think it would really clear the air for a lot of the opposition and certainly for myself. Thank you.
Senator Pazina?
Thank you so much, Chair, and thank you again for the presentation. Just one final thing so I can understand this. If AB 364 were to pass, does that mean that then direct supervision will not be required for PAs?
For the record, Madam Chair, John Sandy. So I think with Senator Stone's recommendation right there is something that we are going to definitely look at. With that amendment, then yes. I think the way the bill is drafted right now, it leaves it to the facility where there are doctors present to decide the scope and whether even a collaborative agreement is necessary. But from the information we're getting, requiring that there is some sort of collaborative agreement might put at ease a lot of the concerns. And so, like I said, we're definitely going to look at that. So to answer your question is, the bill is before you, not necessarily. With a proposed amendment that I'm hearing, then yes, it would.
Thank you. And I understand that there was some assertions, someone said that this bill also gives PAs the authority to do some things that APRNs are now doing. Mr. Fernley, can you speak to that, please?
Yes, there are various provisions of the bill that provide that physician assistants have similar authority and duties to other providers of healthcare who provide services. I'm happy to go through those sections and provide the committee with a list of what those services are. But just as an example, Section 1 would authorize physician assistants to do the form that is submitted to the DMV to indicate that a person has epilepsy such that they aren't able to drive. So that is currently a form that can be done by a physician or an APRN, and that's an example of where physician assistants are being added in to have additional ability to do those kinds of things.
Thank you. Additional questions? Okay, yeah, and I just want to emphasize this again to everyone in the room and anyone who's still listening online. If you know that someone is acting outside the scope of practice, I believe there's a moral obligation to report that and not just come to this committee and say that, because that means that you know there are people putting the public at risk. And I believe that there's a moral duty and a moral obligation to do that. And we will make sure that that's in statute for those who moral compass might be broken, so it's really clear. Okay, so with that, I think we're done. Thank you so much. We'll close the hearing on Assembly Bill 364 and the changes that have been recommended. I'd recommend that you get with the sponsor and with Senator Stone, and please stop and see me as well, so that we can make sure that happens, especially the duty to report. Okay, thank you. So we'll close the hearing on Assembly Bill 364, and we'll now open it up for public comment. Public comment is 2 minutes, and it does not include anything that we've talked about with any of the bills we've heard today. Public comment is completely different, completely separate. I don't see anyone moving to the table in Las Vegas. I don't see anyone moving to the table in Carson City. BPS, is there anyone on the phone for public comment?
If you would like to provide public comment, please press star 9 now to take your place in the queue. The public line is open and working. There are no callers at this time.
Thank you. Committee members, further comments? Questions? All right. So with that, we will adjourn today, and we will be right back here on Monday at 8 o'clock. We'll see you then. We are adjourned.